work. Work, 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 work. Oh, whoops. Wrong set. Sorry, hold on. Is that the right one? Yeah. Yeah. Work, 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 work. Gotta work, 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 work. Gotta work, 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 work. What's that? What's going on out there? I can't see anything because the screen's too small. Bump, 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 bump. Well, welcome back. Hope you missed me. I don't have any viewers. What? Oh man, I knew this. I knew this. Damn it. Damn it. Oh. Oh yeah. Yeah, I do remember that. Hi Neil. Everybody. Hi Neil. It's just you and me. There's no one else here. I pretty much put myself right into no. It's nice to see you too. Oh my god, everybody's breaking up the joint in here today. I got sirens outside. I got my cat beating up his kitty box for some reason. And no, it feels like I never left, which it could be good or bad. That could be a good or a bad thing. But yeah, no, it's nice to be back. I'm really happy to be back. Oh well, I tried. Actually, the break was really, really good because I just got to kind of like hang out. I'll be honest with you. That was actually kind of nice. I thought there would be a crowd because I was 2 minutes late. No, Neil. There's no crowd. Hi, give me coffee. How are you, darling? Welcome back to the Wake and Bake. Guess who's back? Back again. Lolo's back. Tell a friend. Guess who's back? 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 Thank you. And thank you, my friends. Tom, good morning, darling. Yeah, I definitely, well, and I don't know. I think my batteries are a little off kilter, you know? I think I need a tune-up. I need a little bit of a tune-up. But I'll definitely work on that. Yeah, good morning. Jesus fucking Christ. Here we are. Jeez, I leave you guys for 2 weeks and look what happened. What the fuck, you guys? Come on. Maybe you've been driving yourself too hard lately. No, I don't think it's, well, Neil, I think I'm just in a different headspace. You know, like, I am really struggling with some medical, like, mental issues. And I have not seen my doctor, my psychiatrist, to kind of readjust medications and things like that. I need to see my psychiatrist. I need to see all my doctors, actually. So it's really, I think it's kind of, I'm just trying to make it in this world, and like everyone. And I struggle these days. And it's funny because if you met me in like early 2019, I think you'd meet a slightly different person. I mean, not really, because I've always been like this goofy and stupid and, whatever. But you would meet a person that has much more responsibility in her life and who is not usually this way. You know what I mean? It's just not usually this way. And I was always go, go, go for like about 33 years, like everyone. I mean, I'm just describing the same thing everyone's been through. I'm not describing anything special. I had events in my life in late 2019 that changed my trajectory. which I've talked about a little bit, but not much, and I don't intend to talk anymore too much about them. Hi, peace, love. But in 2019, my life before COVID actually changed dramatically, and then COVID didn't help, like it didn't anyone. Hi, Teresa. How are you, darling? So I really am not the same emotionally or mentally that I was when I was kind of doing my jam, for decades. I mean, I was like a business lady, and I was, well, not business, but, I was nonprofit, and I was a leader. I was like responsible for things. And I don't know, all of a sudden, it just all fell apart because, again, of things that I've been through, and, nothing unusual that other people haven't been through. So yeah, I'm in territory that I don't really understand the last few years, last 5, 6 years, God. And it's been a journey, as it has, again, for everyone. I don't think my story is unique or special, but it just happens to be the context that might be needed for when I do things like that and take a break and really feel not effective. The funny thing about having this kind of what I wanted to do online, and I just want to make sure, hi, Jane. I just want to make sure that, hi, peace, love, darling. I just want to make sure people understand, this to me, like I have always wanted to be a performer in my life. I've always wanted to be a comedian. I've always wanted to be a singer, but I was, again, like many people, had to work. I couldn't afford to go back to school. I couldn't afford to, just quit my job and, try to be a comedian. I couldn't do any of those things. I had to raise my baby because I was a single mom from the jump. And so I was busy raising my kid, right? Like trying to do my shit. And responsible, for that. And I think that since, some stuff happened in 2019 and then, eventually through COVID and all the things that came along with that, I can't, I'm going through a real journey of self-discovery these last 6 years. And frankly, I'm kind of tired of it. And it's just hard because, I don't know. I'm not going to go on about it because it's going to start sounding like complaining. And I really don't want to complain because I feel very lucky to have all of you, my friends. You guys really you always keep me going. And it's not your job to keep me going. Please, I know. And I also worry that when I do things like taking a break, that that it comes off as disregarding how wonderful everyone is when they support what I want to do and just be part of it, right? Not even support it, just be part of it. So I have like guilt feelings too. Oh, really? Yeah, I have guilt feelings because I'm so appreciative of every fucking person that comes in and just like fucks around with us, So I don't. It's not fame that I want because I think that time is really, I just don't think that's important. And the money isn't important right now because I'm lucky to be with my daughter who's working and I'm getting a little bit of money coming in. So good, because that's really where it is. And I kind of go to the point, Jane, where I can't go anymore. You know what I mean? And here's the other thing. This is interesting. Here's the other thing I feel guilty about. Welcome to my therapy session. Thanks for coming. No, the thing I feel guilty about is what is happening in the world right now and what is happening to people in the world is absolutely horrific and of the utmost urgency, right? Of the utmost urgency. And so I also feel guilty because I don't, I don't feel like my issues are equivalent to what the rest of the world is going through, So I don't know, that carries some guilt. with it too. I'm so glad. Give me coffee. Thank you so much. Oh, I think that's so good. We've been on some wild journeys since 2017 or sure. Yeah. Along with that, some epiphanies. Yeah. I mean, I think, and that's what life is, right? You just go through a series of, oh, oh. And so, my life is no different. I kind of do that. Yeah, I could have gone a very different path. Oh, yeah, I had a couple paths I could have taken, but thankfully didn't. But yeah, it's oh, thanks, butterflies. Oh, I've learned something every day here. Butterflies, I love you so much. We've been through a lot. But yeah, no, I just want you to know. I really do appreciate every time someone comes in and is watching something with me or whatever. That just makes my fucking day. And that's where my desire for more eyeballs comes from, is I want this type of information. I want to get better, first of all, always. But I want this type of information out there. And my 2 weeks off really just kind of showed me that there's so much crap on YouTube that we need more voices on YouTube who are empathic and reasonable. Hi, Lee. Good morning, my darling. It's so good to see your little name. I love you, girl. I love you, sister. Oh, it's nice hearing your voice in the morning. I did pop into your video game yesterday for a couple of minutes and heard you and Bobo. Made me chuckle. I know. Thanks for that. I know those games are kind of boring, but I don't know what I'm doing when I'm like, maybe someone will want to watch it. Same butterflies every day. I love it. This is my favorite place in these streets. Yay! Peace, love. I thank you. Thank you. Yeah, well, this morning we have some SCOTUS shit to deal with, so it's not going to be that fun. Anyway, all to say, I'm a nutty girl, and sometimes nutty girls just get in their feelings. And they need some affirmation from their friends. And there's probably a lot to unpack. I probably need to go to a professional and unpack a lot of what I'm going through. But I really am just like doing the best, as everyone is, doing the best I can, trying to make it from one day to the next, trying to always question myself. What can I be? Can I do something more? Because I don't do enough. I don't do nearly enough in resistance to this administration. And I definitely want to do more. Took a friend for a drive along the St. Clair River yesterday, waved at Canada across the river. Yeah. Lee, don't go. I mean, no one should go anywhere, okay? Canadians, stay home. Canadians, just stay home. Don't come to the United States. It's crazy. I have to go down by a local university and a couple will take y'all with me in my pocket. Oh, yeah, I will definitely wish you luck finding parking. Good morning, Gal. Yay, Gal's here. Woo, whoop, whoop. Hi, bud. Hey, bud. Yeah, so anyway, yeah, I want our audience to be huge. And then what we'll do, you guys, Fairy in the chat, Tanya. Hi, Fairy in the chat, Tanya. How are you? Good morning. Good morning. Good morning. Good morning, Fairy. How are you? Welcome to the Wake and Bake with Lolo. The traffic into the U.S. on the Blue Water Bridge was all commercial. Really? See, I wouldn't be shocked by that. You know what? I was listening to some Canadian chuds yesterday, as I do. And they're scared. They're scared. I'm good. Thank you. Thanks for asking. I'm so glad. I'm glad you're here. You know, like, they're, what was I going to say? They're scared. They're kind of scared. They saw the story of the Canadian woman that got arrested or detained or something by immigration. And it's like, hey, Al, how are you? Hell yeah. God, good reminder. Al Munson coming in with the good reminders that waking and baking is part of this. You brought coffee cake? Fuck yeah. Fuck yeah, Lisa. Neil, I think we met on Peace Life. Oh, I usually don't like to recognize my birthday, but today I want a song. Teresa, do you have a song in mind? Let's see. Let me think about that, because we should sing a song. I hope you'll like it here. I hope you like it here, Fairy. Sometimes it gets a little nutty. A little nutty. Tanya. Is it Tanya or Tonya? Tanya? I would say Tanya, because that would be my pronunciation, but that could be off. Let's see. Happy birthday, Teresa. My sister Teresa. My sister T, we've been fighting trolls on Twitter for years together. Happy birthday. No, I need to sing I need to sing you a good song. Anything will do. Okay. All right. Well, I'm going to start with just happy birthday. And then, okay, Tanya. Sorry. I don't know why. Tonya. Who the fuck would ever call themselves Tonya? I'm so sorry. I guess I'm not trying. I'm not high enough yet. All right, here we go. Teresa, you're my girl. All right, let me tell you. You are a fucking badass. You are my breaking news source. I know, but it's all Tanya. You are my breaking news source. You are my sister in sledgehammers. And I love you. And I just want you to know that. I love you so deeply. Oh, thank you. Peace, love. That means everything. Thank you. I'm so glad. I hope it just takes your mind off something, right? Like, I hope it takes your mind off something. Badger, are you here? Good morning, Badger, Badger, Badger. I love you. All right. Well, today it's Teresa, aka T. It's her birthday. And I want to sing her happy birthday. All right. God, I'm actually nervous. I've never been nervous before. Now all of a sudden I ruined the moment. Oh, Teresa, happy birthday to you. Happy birthday to you. Happy birthday, my dearest sister T. Happy birthday to you. I love you. I love you so much. I hope your day's so great. I hope your month is great. It's birthday month, by the way. There's no birthday. It's birth month. Okay, we're going to have to, let me tell you about what's going to have to happen under this regime. Okay, can I take you to a place for a minute? Teresa, I love you. Happy birthday, darling. We have to embrace the comfort and the silly. Okay? So whatever is your like silly comfort, oh baby, I love you. Don't cry. Embrace everything that is silly and comforting, right? I don't want people to ever hesitate. Like if you need a stuffed animal and you're 61 years old, fucking get a stuffed animal, okay? Because frankly, kind of resisting through this time is going to be really important, and we're going to need all the strength that we can get, even if it's from things, right? Touchstones and things. So I highly recommend finding whatever that is for you, because I know some of you are not, you're not in the persuasion of doing goofy little things for yourself. Thank you. Thank you, Tanya. Thank you. Fuck yeah. I don't even know. Where is it? I got tons. Wait. I got this. I got this for my birthday. It's the Care Bear, and his stomach lights up. So you know what? Fuck all of you. Al Munson. Wait, I need to say hi. I didn't even say hi to Al. I'm so sorry. Al's probably gone by now. But Al, thank you for coming in. I appreciate you. I'm telling you. I just like oh, Teresa, I love you so much. No, it's like do what you need to survive, okay? We're not doing any more of the like, oh, I can't do that because I'm an adult, or I can't do this when I'm a this, and I can't do that when I'm a that. You know, you can do whatever the fuck you need to right now, okay? Everyone needs a Care Bear. Care Bears for everybody. No, I'm just kidding. No, I'm serious. Oh, Lee, that's so cute. I have Snoopy from when I was a child and a Woodstock on my bed next to the pillow my mom crocheted for me. I'm telling you. That shit's important. Those things are like touchstones. Those things change your perspective. Not everybody, okay? I get it. Not everybody's into that. All right? I'm not judging at all. At all. I just hope you don't judge me, but I'm not judging anyone. Yeah, but you can fuck off. Yes, Teresa. I don't know. They're making some good Care Bears these days. You might want to check them out. I don't know. I think we're going to start a trend here or something. Yeah, I don't know. It's just like I'm doing whatever I can to soothe myself because everything is just like, oh my God, my eyes watering again. Everything is just too overwhelming, right? Like it's just too overwhelming. There's no two ways about it. And speaking of overwhelming, let me tell you about this case. This case is overwhelming that we're about to hear. Yeah. Oh, and I started writing a Substack last night. I'm not doing any subscriptions. I mean, they make you do subscriptions. Don't subscribe to my Substack. Okay? Don't subscribe to it. It will all be free and accessible. And it's really just my place to journal. That's what it's going to be. And so last night I started this huge Substack. And I'm going to see if it is worth reading or worth sharing. I'm not sure. The Care Bears are way cooler now when they were back in the day. Yeah, I agree with that. It's a whole new Care Bear world. Okay. You gotta check back on the Care Bears. That's what I'm trying to say. Did you hear about today's protest at the U.S. consulates? Neil, is there protests in Canada today? That's fantastic. I saw a wonderful, what was it? Protest in Edmonton this weekend. They were protesting Tesla, which I thought was great. I really think the Tesla protests, I know they're kind of fraught with opportunities for everything. Infiltration, blowback, all that kind of stuff. And oh, Fairy's birthday tomorrow. Happy birthday tomorrow, Tanya. Happy birthday to you. It is birthday month. Wow. You guys are like, you're killing it over here in March. You're making March go out like a lion with all these birthdays scheduled. There are protests scheduled at all the consulates in Canada and the embassy in Ottawa. That's great. There was a huge protest in LA. Where? Which one? Did you see Dave's latest on Substack? I should look at that. Good morning, Max. A guy by the name of Andrew Detill drove through some Tesla protests in Miami. I think I did see something like that. Yeah, Gal, this is the real advice in these times is the administration is looking for reasons to hammer down on freedom of speech. I'll just leave it at that. You know, whether or not they're like into martial law and all that stuff, I don't know. And so I'm not going to really say if they are, but it's a possibility. Yeah. Oh, against Tesla? Damn. What did I miss? I missed? Fuck. I gotta figure that where people are. Just the Substack dilemma. How creators are inadvertently fueling America's failure. Damn it. Stop it, Max. What? God damn it. Why I advise going with the union. Keep an eye on who's around our protests and pickets. Yeah. That's actually not a bad idea. Yeah, the union people know how to protest. They know how to keep people out of their protests that aren't legit. But yes, Gal's admonition about Tesla protests in particular is wise. Remain nonviolent. They want propaganda to justify authoritarian actions. They really do. And it's such good advice. And it's very hard. I screamed at people at the Tesla dealership. So, I mean, I think that, and I did scream at a couple of Tesla drivers. I'm not doing that anymore because in LA, people will shoot you and I don't want to get shot. So I'm not yelling at many Tesla drivers. Hi, Oomph. Good morning. And so, yeah, it's like, all right, whatever. So, but yeah, oh man, bummer, Tanya. I wish I was around for it. I was just like doing shit around the house. It was terrible. If Trump sends troops to quell our protests in Canada, we have a bigger problem on our hands. It's true. Is the Tesla on Hollywood Boulevard? What? Oh, I'm mad at myself now. I am mad at myself. What the fuck's wrong with me? Okay, well, do you happen to know who was organizing it or no? If you don't, that's fine. Was it it wasn't the Tesla takedown people because they're doing something on March 29th. So they're doing something next week. But I will definitely check that out. There's a Tesla dealership on Hollywood Boulevard? Where's the Tesla on Hollywood Boulevard? I don't even know where that is. It's every Saturday? What? Where is this? What is wrong with me? Okay, well, that's it. I'm finding those people. I don't know who they are, but I'm going to find them. Interesting. Very interesting. Well, the dinosaur has to get out there again. Usha and gang in Greenland. Yes, Lisa. Oh, yes. Yes. Let me read. Wait, I got to look at what Gal pulled up here because it's relevant to what we were talking about. Talking about. Okay, as suspected, the narrative they're going to run with Tesla protests is the same exact propaganda from summer 2020, burning down cities. Do not give them propaganda footage. Remain nonviolent. That's the advice. Coming from my friend and yours. Coming from my friend and yours. Okay, where am I? There I am. Where am I? Where am I? Oh my God, my nose itches. I'm going to kiss a fool or have a fight. Is that it? Yeah. All right, so this is what Tesla terrorism. This is Fox News, and they're very frightened. Everybody's really scared. I think these people have
probably done other things before this. If they're so bold, they think they can get away with it. These are probably the people who are burning down the cities after all these Black Lives Matter protests, right?
Yeah, such a great point, Tom. And the reason why Pam Bondi is expanding the investigation, because a lot of people don't believe that it's just these people, that there has to be money behind it, that there might be organized efforts to target Tesla on a bigger scale.
Decades. I think these people have probably done other things before this.
Okay, this guy is a fucking douchebag. Okay, he's a douche whistle. He's a douche nozzle. I think that's where it is. I remember I'm not from LA. No, totally, please. Anonymous Lens. Okay, I will definitely look at that. I should find her where she is. All right, Anonymous Lens. Okay. Peeps who are bathing too aggro, move away and isolate. Yes, Pepper. Good morning, Pepper. It's in Pasadena. Oh, okay. No problem. Tanya, I know which one you mean. I've been going to the one in Santa Monica because, hi, Paul J. Because there's one in Santa Monica that has a street so that you aren't on their property. The one in Century City is inside the mall and the outdoor mall. But I've already been kicked out of that outdoor mall when I was protesting Dinesh D'Souza's movie. So, and I will say this, let me give a shout out to the Century City Westfield security staff. You guys are professional, and I dug that. I really appreciated you being so nice while you were escorting me off the property. Thank you. But I was hoping there was one on Hollywood Boulevard, because that would be so much more convenient. But I can get to Pasadena. It's just a little bit of a drive. But yeah, I was thinking I'm going to go this week. I mean, probably and definitely on Saturday, I'll go down to the Santa Monica one. Wow. Was this little get together announced? Yes. I put up little savers all weekend. Or just this weekend, not all weekend. Oh, let me check for SCOTUS. Hold on. Because that's what I'm supposed to be doing today. Why aren't I? Oh, wait, SCOTUS blog. Let me go to that. SCOTUS blog. Oh, itchy nose. Itchy nose. All right, so let's see here. Oh. I thought they were having a thing today. I thought you were having a thing. I'm so confused. I really need people to be much clearer about what they're going to do, when they're going to do it, you know, that kind of thing. Bop, bop, ba-da-bop, bop, ba-da-bop, bop, 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 ba-da. Here we go. I think this might be, okay, something's definitely wrong with my sound. Hold on. I'm so sorry. Fuck. There we go. I think that's better. I don't know. We'll see. This is what I wanted to show you. Right? Wait, where is it? Sorry. The SCOTUS is particularly hard to find, like, their fucking things. Well, let me actually show you what I'm thinking about while I'm looking for it. All right. This is the case. Oh, no, actually, this might not be the case.
Today. Now, at issue is this new map. It was approved last year.
This is the problem.
And it created a second majority black district.
That's
the
what it is.
6th district.
Sorry.
And you can see its unusual shape. It stretches from Baton Rouge in southern Louisiana all the way up to Shreveport. Let's bring in Rebecca Royfee now to break down this case for us. She's a CBS News legal contributor and former Manhattan prosecutor. Rebecca, good morning to you. There are claims of racial gerrymandering at play here, but what is the central issue in this case?
Thanks. Good morning, Errol. Yes, so the Voting Rights Act, Section 2 of the Voting Rights Act, prevents states from engaging in election practices that deprive people of the right to vote based on race. And for decades, states have engaged in some practices involving drawing maps that include majority Black districts in order to comply with that provision. But now what's happening is challenges repeatedly based on the constitutional bar against racial discrimination, claiming, as you said, that these are racial gerrymandering. So states are essentially sort of stuck between a rock and a hard place where they're trying to comply with the Voting Rights Act. And doing so, they are drawing some maps that have, as you say, strange patterns that are done in order to create district in which there is a majority Black population. And in doing so, they're being met with these challenges that this is a constitutional violation. So what's at stake here is the future of the Voting Rights Act. Will the court, which has been notoriously opposed to any kind of practice that takes race into account, gut the Voting Rights Act and prevent states from doing this, which is essentially a way of making sure that Black people have a voice in politics?
And we've seen multiple redistricting cases in the past few years since the Supreme Court weakened many key aspects of the Voting Rights Act, from Alabama to Georgia and North Carolina, for example. So what can we expect the justices to focus on for Louisiana?
Well, I mean, there's always the possibility that they decide this case based on some procedural grounds. But if they take up the substance of this case, I think what's at issue is the future of the Voting Rights Act and how states engage in election practices, whether they can ensure that, for instance, in Louisiana, where Black people make up 1/3 of the population and previously only had one district in which there were majority Black people, this particular map was an effort to fix that and make it such that Black people had more of a voice in what was going on in politics in that state. So will they be able to continue those practices, or will they be forced to engage in, more colorblind activity, which may result in the weakening or the watering down of those voices in Louisiana politics?
Yeah, we'll continue to watch this for sure.
Okay. This should be it. But it's not started yet. Okay. Well, it hasn't started. But that's what we're watching. I guess. Has it started? I don't hear anything. I think they're late. I think the SCOTUS is late. Good morning. Good morning. It's Teresa's birthday, Iggy. Oh, you got it already. And it's Tanya's birthday, who is a welcome addition to the fam. Introduced by Peace Love. Thank you, Peace Love, for sharing the goodness. I appreciate that. You and Boston Brian should do a collab. That would be a really fun show. I love Boston Brian. I think he's hilarious. I love Hal. I love all those guys. That's like my favorite leftist leaning podcasty type stuff. I think Hal does an amazing job. I think he's like really, he knows his shit. He's on top of like the ins and outs and who's who. So I'm down with that. I think he's really good. But thank you. Yeah, I think it would be fun one day, someday. Yeah, happy birthday. Everybody's got a birthday today. Yeah, or tomorrow. Wow, what happened? I thought I was late. What happened? I guess we're not late. Yeah, so this week it's very busy too. Let me tell you how busy it is this week. It's very, very, very busy. All right, tomorrow's crazy. Tomorrow is insanity. I think Iggy, I don't know, are we going to have a space tonight? Gal, Iggy, are we going to have a space tonight? I'm banned on Twitter right now until like Wednesday or Thursday, I think. For telling Don Jr. that I think he should be hung upside down, not by the neck. Okay. I don't want to hurt him. I just want him to experience what he needs. I can use one. Well, but see, it has to, if we host it, it's who hosts it. That's what it is. Although I guess my other, you want to be Gal or 5GW? No, I can go in under my other, but people will have to, I don't know if no one follows my other account. So maybe Gal or Iggy, if you can host tonight, then we'll have a name attached to the space. Does that make sense? But if you can't, I totally understand. All right, I'm going to shut up. Here we go. Thanks, PBS, for not giving us any names. Okay, no problem, no problem.
Justice, and may it please the court. Louisiana would rather not be here. We didn't want to be in the emergency docket in 2022. We didn't want to be on the emergency docket in 2024. And today, I mean, God bless my friends on both sides of this case, but we'd rather not be caught between two parties with diametrically opposed visions of what our congressional map should look like. But this has become life as usual for the states under this court's voting cases. And our fundamental question today is, how do we get out of this predicament? Now, I think there are at least three ways to do that. First, you should reverse on standing grounds, because the only theory of harm in the red brief is that our black representative of District 6 will play into racial stereotypes by favoring the black voters of District 6. Second, you should reverse on racial predominance, because the district court wrongly assumed that our intentional
There's a background.
Oh,
I don't have a secret identity.
In light of the Robinson decisions, automatically established
what you see is what you get.
Predominance. And third, you should reverse on the good reasons inquiry, because the district court wrongly, in our view, believed that the Robinson decisions play no role in the strong basis in evidence inquiry. And in the end, I want to emphasize
that's called
that
Lolo,
the larger
let
picture
me.
here is important because in an election year, we faced the prospect of a federal court drawn map that placed in jeopardy the Speaker of the House Majority Leader, and our representative on the Appropriations Committee. And so in light of those facts, we made the politically rational decision. We drew our own map to protect them. This court's breathing room precedents allow that decision. I welcome the court's questions.
So as I understand your argument, we are to accept that
no, this is a different one.
The Robinson court
different one.
That there be 2 districts.
The other ones are suspended.
And your only interest is in preserving 2 incumbents in northeast Louisiana.
That's correct, Your Honor. I mean, we have 2 Article III court decisions that say the VRA likely requires Louisiana to draw a second majority black district. Those were the facts presented to us. In light of those decisions, we said, well, we can't allow the federal court to draw the Robinson illustrative maps because that would have placed Julia Letlow in a majority Democrat district. And so we took matters into our own hands and said, we're going to protect our most high-profile incumbents, draw our own map that ensures that Speaker Johnson and Representative Letlow remain in Congress. And
so in order for us to use that line, wouldn't we have to accept that the district court was right, the Robinson court was correct?
Your Honor, I think the way this case has been litigated, the way it comes to the court, the plaintiffs have not put on a pseudo-VRA case to say that the Robinson courts were wrongly decided. I mean, of course, as you know, in the Robinson litigation, we took the position that we should have prevailed. We lost. We lost on those arguments. And at the end of the day, I think in the strict scrutiny analysis that this court's cases set out, the question is, do we have a good reason in relying on what the federal courts told us that the VRA likely required? And I think that's the fundamental error. If you look at pages 53A to 66A of our JS appendix, that's the district court's good reasons analysis. It says not one word about the Robinson decisions. And with all respect to the district court, I think that's not how the good reasons inquiry runs. I mean, I think fundamentally, when you have Article III courts telling you that this is what the VRA likely requires, a rational state is going to run with exactly what the federal court says. We're in the business of complying with federal court decisions. And when they told us that we needed to draw a second majority black district, that's what we did. And I want to go back to the larger context because I think that's the important factual backdrop here, which is we're in an election year.
Oh, Pepper, that's interesting.
The Fifth Circuit, if you look at page 601 of its decision, the Fifth Circuit says you have a few weeks to, now that we have affirmed the district court's likelihood of success on the merits finding, you have a few weeks to go back, consider drawing your own map. And it's an election year. We're talking about the Speaker of the House. No rational state gambles with those high-stake seats in that situation. And our request to this court is to say, well, given that unique circumstance where you have 2 layers of Article III courts telling a state what the VRA likely requires, that is a good reason for the district, for the state to do what it did.
Well, I mean, do you think the Robinson court was correct?
Your Honor, you know, in our heart of hearts, we've never shied away from our position in the Robinson decisions, which is that we should have prevailed. At the end of that litigation in the preliminary injunction stage, we lost, and so we faced a choice. Do we take a gamble and go to trial, lose at final judgment, endure a court-drawn map, and hope that an appellate court will then step in on the back end of the process and save us from the federal court-drawn map? Or do we say, if the court said what they said, what the VRA likely requires, can we work with that and find a way to save our incumbents on our own? And so, Your Honor, I'm not going to stand here and say that the Robinson courts were right, but I will say that what is set in stone is what they said. That is the law. And we took that as gospel and went back to the drawing board and drew District 6.
One of the arguments that the
No, you're right, Max. 7425. Get off of Twitter.
There's a durational limit on the authority of Section 2 to force states to create additional majority-minority districts. I think that's pages 36 to 38 of the Appellee's brief. I know that the state of Louisiana in separate litigation is taking exactly that same position as I understood it and read it. And I'm wondering what you think we should do with the Appellee's argument about the durational limit here.
Sure. A couple of things, Justice Kavanaugh. The first thing I think you do is you disregard it because until the red brief, plaintiffs in this case never disputed this court's assumption that compliance with the VRA is a compelling interest.
Good job, Tanya.
Part of the brief where they talk about what we're arguing in another case, that's really beside the point here because they forfeited that compelling interest argument. But on the merits, absolutely. In the Nairn case, our position is that in Louisiana, at least as applied to Louisiana, Section 2 is unconstitutional. The reality today is
we should watch that heritage thing.
And, you know, we are duty bound to comply with the VRA. And especially in this context,
yes, ex-cancel to monitor shitter.
What the VRA likely requires. I don't think there's any serious argument that that is not a compelling interest, that we do not have a compelling interest in complying what the federal courts have told us.
Hi,
that
Kathy.
Separate litigation's now in the Fifth Circuit, is that correct?
It's in the Fifth Circuit. In the Nairn case, the Fifth Circuit panel heard oral argument in January. That issue may well be before this court. The ultimate unconstitutionality issue may well be before this court this fall. But at least as things stand now, we're duty bound to comply with the Voting Rights Act. And when a district court and a panel in the Fifth Circuit say the Voting Rights Act likely requires you to adopt
well, that's subtle, gal. Claremont, you're so subtle.
What if the Robinson decision were plainly wrong? Let's say it didn't apply Gingles at all. Would you still have a good reason to follow it?
No, Justice Alito.
Just tell Jane.
I know the United
just
States
tell Don Jr. you think he should go to
Gitmo.
Gitmo.
Sort of unusual circumstance that provides
You'll
a
get
very,
suspended.
very narrow exception to our position, which is you can imagine an extreme case where the VRA courts just wildly got the law wrong, got the facts wrong, and nobody, as an objective matter, nobody would agree that that was a circumstance where a state could reasonably rely on those decisions.
What if it weren't wildly wrong? They didn't just ignore Gingles, but it's wrong. You look at it and it's wrong. They misapplied something.
And Your Honor, I think that the less wildly wrong the decision becomes, I think the harder it is for a plaintiff like plaintiffs in this case to come in on the back end in an Equal Protection Clause case and say, we should just relitigate what happened in the VRA litigation all over again. And that didn't happen in this case. I mean, nothing prohibited plaintiffs from coming to the district court and putting in all the evidence to say, like, if you actually look at what was in the record in Robinson, flat wrong, you should just relitigate what happened in the Middle District and the Fifth Circuit. They didn't do that. I think that option is available to plaintiffs in a future case.
You're saying in this case, they didn't argue Robinson was wrong.
Your Honor,
they didn't put in any evidence to relitigate the Robinson issue.
Justice Sotomayor, they did not put on the full panoply of evidence that was in the Robinson litigation.
They say you bear that burden.
Your Honor, our burden was to show that we had a good reason for enacting District 6. And our position is that you have two Article III court decisions that go through the Robinson plaintiff's likelihood of success on the merits. That itself is based on the evidentiary record in the Robinson litigation, almost 400 docket entries in the district court in the Middle District.
I'm taking a step back, okay? If they had said that Robinson was wildly wrong, they would have relitigated in front of the district court based on the very voluminous district court decision. It was over 150 pages, filled with the arguments on both sides, right?
That's exactly right, Your Honor.
But what they came in instead and said was, merely because you were trying to comply with Robinson, that showed you let race predominate, correct?
That's correct, Justice Sotomayor.
So their approach wasn't saying relitigate Robinson, they're just saying that's not a compelling state interest.
That's correct, Justice Sotomayor, and our position here is that can't be right. I mean, this court has never seen a set of circumstances where you have federal courts telling a state, this is what the law likely requires of you, and then—
But we do have at least 3 cases that say you don't have to be right on whether you needed to comply with Title II, you just have to have a good faith basis, correct?
That's right, Your Honor. You have a case, for example, you look at a case like Bush versus Vera, a case that says the state doesn't have to draw the precise compact district that a VRA court would have drawn. Or you look at a case like Bethune-Hill that says a state doesn't have to show that it would have lost at trial but for its use of race. I mean, that's the sort of breathing room and flexibility that this court's cases bake into the analysis.
Now, we have at least 3 cases that have said, unlike what the district court said here, the district court said that the reason why race predominated is because you decided to comply with Section 2, correct?
That's correct, Your Honor.
And in at least 3 cases, we've said that's not the starting proposition, correct?
That's correct, Your Honor.
One of them, Baton Hill.
That's correct. This court has said.
So, but we have said that once you try to comply with Section 2, that the new map you create has to substantially address the likely Section 2 violation.
That's correct, Your Honor.
All right. How does the map that you enacted do that? We know the Robinson map was more compact, followed more traditional criteria than the legislature's first created map, okay? So we know that that would have resolved the Section 2 violation using traditional criteria. One of their arguments here, and one that the district court pointed to, but wait a minute, this map's different, and it doesn't fit all the criteria. So how do we say that that follows our guidance?
Mr. Chief Justice, may I briefly answer? So, Justice Sotomayor, I think you begin with the Robinson illustrative maps as a baseline, and you ask how closely does the state's enacted map approximate what the Robinson illustrative map looked like and did. And then if it deviates, you ask that substantially addresses question. Well, why did the state deviate? And did it deviate so much that the state's map doesn't actually substantially address the baseline violation identified in Robinson? And the answers to those questions in this case, the only reason we deviated from the Robinson illustrative map is to protect our high-profile incumbents. And then
both maps created seven voting districts, correct?
We have 6 districts, correct? You're right. Both maps created 2 majority black districts.
2 majorities, but both of them relied on the same district, having the same number of districts.
That's correct, Your Honor.
And 70% of District 6's, which is was 70% of the Robinson map, correct? District 6.
That's correct, Your Honor. The very core of District 6 is the very core of the Robinson illustrative maps.
We have also said very clearly that if 2 reasons coexist, race and politics, that 50-50 means that race doesn't predominate, correct?
That's what this court's precedents say, Your Honor.
Thank you.
Thank you, counsel. Justice Thomas? Justice Alito? Okay. Justice Kavanaugh?
What's the limit on that in terms of your answer to Justice Sotomayor? 50%, 40%, 30%, and what kind of guidance do you think we could give? Because one of the legitimate concerns of your brief and the amicus briefs are to give clearer guidance. What do you think the limit is on taking the political considerations into account in fashioning a remedial district that substantially addresses the violation?
Well, I think one of the limits, Justice Kavanaugh, is numerical, right? I mean, in Shaw 2, the court said that a 20% overlap was insufficient. In LULAC,
yes, SCOTUS is not taking up Steve Wynn's case.
70%. So I think as a numerical matter, that's going to be one pretty clear guidepost for the lower courts on how closely a state is approximating the illustrative map. And I think the other thing is just to really assess why the state deviated from the baseline map. And I think that's one of the things where I don't know that there's any dispute in this case on both sides why we didn't adopt SB4, we adopted SB8. The sole reason, in Senator Womack's own statements, is SB8 was the only map that would protect our high-profile incumbents.
So the rule I think you want is political considerations are fine to take into account in doing the map, the second map, and 50's kind of a floor on that.
I think so. I mean, this court has never spelled out what substantially addresses means as a numerical matter. And to my mind, if I'm between 60 and 80%, I think that's substantial, but obviously a judgment call for this court.
Thank you.
Are they talking about
I just want to be sure I understand your question to Justice
Oh,
Alito.
thank you so
Justice
much,
Alito
Gal.
asked you, if the Robinson decision was patently wrong, could it still be a good reason? And you said, well, if it was patently wrong, no, but we were obeying the federal court orders, this wasn't patently wrong. What is the point at which, because it's an odd situation, right, where the later district court has to essentially take as preclusive the earlier district court's determination of the Section 2 violation, right? But it's not entirely preclusive because you left room for the later court to say, well, that was patently wrong, so we're not going to follow it. What is the line?
So I think there are two ways in which it's not automatically preclusive, Justice Barrett. I think the first is, regardless of what the earlier court decisions say, when the state acts, it has to substantially address the baseline violation. So that's one way in which, if we failed to do that, if we adopted an SB 8 map that had only 20% overlap with the Robinson illustratives, then that's one way in which the VRA decisions are not preclusive here. We lose this case. I think the other way, and I think this is what your question was getting at, is that in the wildly wrong case, I think we just can't we can't dispute that there may be some case where objectively, on both sides of the aisle, everybody agrees that the court just got the law and the facts wrong. I think that's a case we have to give up, and we're happy to give it up. But barring that case, when a federal court, two federal courts tell a state what the law requires, to me, that means that there should be a very, very high bar in this court's precedence for second-guessing what those federal courts say. And I think you just leave that hypothetical out there as a potential odd case that may never arise, but we acknowledge that, it is out there.
I mean, is it also because of the position that it puts the state in here? I mean, it's not just a matter of your obedience to the federal court order, which I appreciate, you would be obedient to the federal court order, but it's also that if you had continued to litigate the Robinson If you had continued to litigate in Robinson, you risked having the court-imposed map. And so it's really your litigation risk that's part of the calculus here?
That's one risk, Your Honor. I think it's both litigation risk and political risk, because remember, if you look at page 601 of the Fifth Circuit's decision, they say, now that we have affirmed the district court on the merits, we don't doubt that the legislature might want to take this opportunity to draw a new map now. And here's a deadline, January 15th, 2024. You call that litigation risk, you can call that political risk, whatever it is, it's forcing the state to make a call.
Well, it's wrapped up together, yeah.
That's correct.
If you're going to lose, then you risk that the district court's going to impose a map on you.
That's exactly right, Justice Barrett.
Okay.
Justice Jackson?
So can I just clarify, there's no dispute that the court's order was the reason that Louisiana did the new map, right?
Mr. Grime can correct me if I'm wrong, but I don't think so, Your Honor.
And the question is whether or not the fact that you had a court order was a good enough reason for you to do it. Is that what you understand the basic question to be?
That's correct. Not just one order, but two layers of orders. Yes, Your Honor.
And I guess I'm still a little confused as to why it matters whether the court order was right or not. You were still being compelled by the court to do what you did in this case, correct?
That's correct, Justice Jackson. And I guess the point I was trying to drive home is that you could imagine, and I think that's why the United States withdrawn brief calls it an unusual circumstance, where the VRA decisions were just wrong, just plainly wrong, and nobody would rely on them. But this is nowhere close to that, and it may well be that this court never sees a situation where that's sort of wildly irrelevant.
But I guess that hypothetical invites us to even engage in a question, an inquiry as to whether or not this was a wildly wrong case. And I'm just worried about that as a way of going about handling this sort of situation. I mean, Justice Barrett points out that we have a prior court order, you say, and it's clear that it was affirmed by the Fifth Circuit, that to a certain extent it is preclusive on the facts of whether or not there's a likely VRA violation here. And having a likely VRA violation is all that was necessary for the state to take the steps that it did. So I just don't know that we need to even engage in the thought process of what if the court order was wrong. Right. I mean, it existed. And if it existed, then it seems to me that there is a good reason for Louisiana to have followed it.
I think that's exactly right, Justice Jackson, and that's why that may well be the unicorn case. The unicorn case that says, black is green. Nobody, objectively agrees with that, but that case may also never arise.
Let me ask you about substantially addressed the violation. Was that something that the district court addressed in this case? I didn't see that as part of its analysis, and isn't that another basis for finding error here?
It did not, Your Honor, and yes, that is an independent legal ground for finding error, and that's why I pointed the court to, if you look at pages 53A to 66A of our JS appendix, that's the good reasons analysis, and you see nothing about Robinson there. You see nothing about the Robinson illustrative maps. With all due respect, that factual background is what explains SB 8, and so you can't assess the legality of our map without referring as a baseline to the comparison against the Robinson litigation.
Thank you.
Thank you, counsel. Mr. Nafee?
Mr. Chief Justice, and may it please the court. This court has been clear that states have breathing room to take reasonable efforts to comply with the Voting Rights Act. And they may also balance the many other interests that enter the redistricting calculus. And so it was perfectly appropriate after 2 federal courts had found that Louisiana had likely violated Section 2 that the state sought to comply with those rulings and that it exercised its authority to protect favored incumbents and unite preferred communities of interest. And accounting for those kinds of political considerations is squarely the legislature's prerogative. And breathing room ensures that courts don't unnecessarily intrude on the legislative domain simply because the state is attempting to comply with the Voting Rights Act. But the district court did exactly that in finding that the state's chosen remedy for the violation shown in Robinson was unconstitutional. And it committed 3 errors in doing so. First, it treated the intent to comply with the Voting Rights Act as inherently suspect. Second, it dismissed Robinson as a good reasons for the state to engage in remedial districting. And third, it demanded that the state's chosen remedy maximize compactness and compliance with traditional redistricting principles, even when that precluded the state achieving its political objectives. Those errors denied the state the flexibility to make political judgments, balance competing interests, and comply with federal law. And so we ask the court to reverse the decision below, and I welcome the court's questions.
Could you take a minute or so and describe exactly what the underlying Voting Rights Act violation was?
Absolutely, Your Honor.
And how it was remedied?
Yes, the district court in the Robinson case looked at the history of discrimination, looked at modern instances of discrimination. It found that there were extreme disparities in the black communities in the region around Baton Rouge, into St. Landry Parish, and into other parishes, and also in the Delta region, which was drawn into our illustrative maps. So it looked at that history. It found that based on that, those conditions, current conditions, not just history, but current conditions, that black voters in Louisiana had less opportunity to elect candidates of choice than other voters. And so it looked at the totality of the circumstances. It found that there was a compact map could be drawn and that race did not predominate in the illustrative maps. And therefore it found, and it looked at the polarization, and it found that Section 2 had likely been violated.
Counsel, what do we do about the fact that Robinson 1 was just litigated through a preliminary injunction? And I understand that the court has suggested that there's a compelling interest in abiding Section 2, but here we don't have a final judgment, and that's a little awkward to say that a preliminary injunction, which even in the existing litigation has no binding effect going forward, right? I mean, you get a PI, you can lose on the merits. Happens all the time, right? So what do we do about that?
Well, I think first, Your Honor, this court has found good reasons on much less than that. It's found good
I did not, Jim.
based
Where's
on,
that being? Let me look for that.
Analysis of past election results on demographics of districts and turnout statistics.
No, I understand that,
like
but here it's based on a court action. But the court action was preliminary.
It was preliminary in a very formal sense, but the record in Robinson was very robust. It was a 5-day evidentiary hearing. The court heard from 21 witnesses. There were hundreds of exhibits, and the court made a reasoned decision based on that record. And not only was it the district court's decision, but that decision was then affirmed by the Fifth Circuit with the benefit of this court's decision in Milligan that found that the district court had correctly identified a likely violation of Section 2. And so under any circumstances, that, under this court's precedent, that's more than enough to find good reasons for the state to engage in remedial redistricting.
Well, it was not only a preliminary injunction, it was a preliminary injunction that was vacated by the Fifth Circuit because there was no longer any irreparable harm at the time when the Fifth Circuit decided the appeal. And the Fifth Circuit said, we're not convinced that this is the right result. This will be the right result in the end. Isn't all that true?
Well, not all of it, Your Honor. First, the Fifth Circuit said that the harm is still present. So it was the balance of the equities, really, that was the basis for vacating the injunction. And you can see that in the Fifth Circuit.
All right, but it's a vacated preliminary injunction.
It's vacated, yes, Your Honor, on the balance of the equities. But the Fifth Circuit very clearly affirmed the merits of the district court's decision, its determination that the plaintiffs were likely to prevail on the merits.
Why is this situation different from the situation in Miller, which I don't think you discuss in your brief, where the state said, we adopted this map because that was required to get preclearance from the Justice Department, and the court just blew right past that. So what's the difference?
I think there's a very big difference, Your Honor, between the Justice Department making a pre-litigation assessment about what Section 5 requires, which in Miller the court made clear would be subject to judicial oversight, and an Article 3 court in an adversarial setting looking at the evidence and making a determination that Section 2 has likely been violated.
Well, I come back then to the question I asked Mr. Aguinaldo. What if the underlying decision, what if the district court decision is wrong? What if you read it and you say this is wrong? It applied the wrong standard.
Well, I think, Your Honor, if there were some unusual circumstance like that, and then you'd also maybe want to look at why did the state not defend it if it was so wrong? Unusual circumstances like collusion, like a responsible official's failure to defend a map, which does happen from time to time, then you might look with more skepticism at the decision itself.
Well, why isn't this a situation where if you look at the face of the decision, it's wrong? And you just summarize what the Middle District judge held, and it was wrong. Under LULAC, it's wrong. The question is whether there is a minority, whether there is a minority population that is sufficiently compact to be included in a district that sufficiently respects traditional districting lines, not whether once you've identified bits of minority
Doesn't that seem like the problem?
It is possible to draw a district that's compact. That's contrary
Keeping
to what
incumbents
LULAC said. And
safe?
It's just that's what the Middle District
How is that fair
said,
to anything?
It's what you just said in summarizing what they held.
Well, absolutely, Your Honor. The standard is the minority population sufficiently compact to form the majority in a reasonably configured district?
Right, we said that in Allen, didn't we? That was pretty recent. That was last year, 2 years ago, whatever.
Absolutely, Your Honor.
We said it in Wisconsin legislature. Sufficiently large and compact to constitute a majority in a reasonably configured district. That's exactly what they did. I mean, LULAC has some language. It actually goes back and forth between the two. But we've repeated now several times, including in our most recent decision, the standard that was used here.
Absolutely, Your Honor. And the way that standard is typically applied is that if there is a reasonably configured district that is majority-minority, that's the evidence that the minority population is sufficiently compact.
I mean, if you look at CD6, what does reasonably compact mean? I mean, it's a snake that runs from one end of the state to the other. How is that compact?
Well, absolutely, Your Honor. So the CD6 is the remedial district. That was not offered as an illustrative district to prove a Section 2 violation. And states have flexibility when they are drawing remedial districts that a plaintiff in a Section 2 case might not have. We can't draw non-compact districts to prove the Section 2 violation. But once we have shown that...
So in Robinson, they were looking at a totally normal looking district, right?
It was a much
kind of square, and it's like there's nothing unusual about it. It actually looks like the district that the state went in with, right?
Absolutely, it's very similar to the state's the CD5 in the original map enacted in 2022. And so that's the evidence.
It performed better on traditional criteria. The Robinson map performed better on traditional criteria than Louisiana's map, correct?
Yes,
First map.
that is correct.
So what do we do about that? You came up with some compact maps. Louisiana chose a snake, as the Chief Justice called it, instead, squiggling from one end of the state to the other. Even if there were good reason for the district court, for equal protection purposes, the state had good reason to draw another district. Did it have good reason to draw this district?
Well, it had good reason to believe that it had to draw some remedial district.
No, I'm spotting you that we're moving past the preliminary injunction stuff, or whether they had good reason. I'm asking, is this one narrowly tailored? Is this one the appropriate district?
Yes, so the question the court asks there is, does the district that the state drew, the remedial district, substantially address the violation?
And that's my question for you.
And so here, as Mr. Aguinaldo explained, the district includes a substantial part of the same population. The core of the district is identical to the districts that were at issue in Robinson, to our illustrative districts. It's about at least 70% of the population.
Of the population, but geographically it's wildly different. And so what do we do about that?
Well, I think the geography is not really the issue.
Not the
because,
point.
as the court pointed out back in the 60s in Reynolds versus Sims, legislators represent people. They don't represent geography.
Exactly.
Yeah, districting is supposed to take into account, I mean, we're going to go around the tree, I suppose, but districting is also supposed to take into account compactness and contiguity, and traditional.
Well, a snake is contiguous.
And this one,
so, you
didn't propose this district.
No, we did not propose this district, but we believe the district remedies the violation because it includes most of the population from the illustrative districts, and states are not constrained. This court has said repeatedly that states don't have to draw the compact districts that a court would impose. They can take other considerations into account, including political ones.
And I'm wondering whether or not we're conflating the standards in a way as we have this conversation. I mean, the original Section 2 violation was established via the map that was compact that you created that showed that another majority-minority district could be drawn.
Not the one that's cut
And
into
in
pieces.
response to that, the state,
Alito.
for political reasons, said we're not going to adopt that map. We need to make a different one in order to reach the goal of remedying this violation because of political reasons. So at that point, I'm wondering whether we are even in a world in which strict scrutiny is applying, because the state's motivation for drawing the squiggly snake map is not race. Its motivation at that point is clearly politics, because that's what it's saying it's doing, choosing that map over the one that you proposed. So do we even need to get into the analysis about narrow tailoring, because it seems we've left it because we're now in the world of political map drawing, right?
Absolutely, Your Honor. And the line this court has long drawn is between consciousness of race and racial predominance. And that distinction is important to preserving states' flexibility to account for these kinds of political considerations while also complying with federal law.
And what I hear you saying is the reason why we're looking at a snake-like map rather than the compact map is because of political considerations.
Politics is the only reason that the state chose that map over the compact maps that were offered in Robinson.
To keep the Republican incumbents safe.
You said what's important on compactness is where the core of the district is?
That's what the articles say.
It's not a question of compactness, Your Honor. It's a question of remedy. Does it remedy the violation that had been shown? This court has never said that states are required to draw compact districts. There's no obligation to draw compact districts if they're not doing it for, if they're not drawing a non-compact district predominantly based on race without an adequate justification. So they can draw compact districts, non-compact districts as a remedy once a violation has been shown.
And you think the drawing of this district was not predominantly based on race?
I think
I mean, it runs from one side of the state, angling up to the other, picking up black populations as it goes along.
Well, Your Honor, that was the plaintiff's position, but as the state identified communities of interest that it had joined in that district in that shape, and if you look at the Louisiana historians' amicus brief, they explain that it's not by chance that there are significant black populations in that corridor along the Red River. It's a result of history. It's a result of the history of slavery, of Jim Crow, and of the disparities that prevented the lack of economic opportunities that kept people there over generations. And so those ties are still there throughout the district. There are family ties, there are community ties, there are religious ties among those communities that are drawn together in that district. And that's part of what the state identified. What the legislature identified was the interests that they were drawing together in addition to the political reasons. So it's not a district that randomly draws together.
So it is geography.
What the chief is trying to get at is certainly politics played a role in this district, but didn't race?
Absolutely, Your Honor. The state was trying to draw a district that would remedy.
This is a very interesting case.
Which is another way of saying race predominated.
Well, I would disagree with that, Your Honor. I think that
yes, it is, Paul Langan.
And this court has long said,
"Darling, you'll never go away."
I'm sorry, Chief.
No, go ahead.
Well, isn't saying race was one consideration another way of saying race predominated? And how do we square that with the 14th Amendment's promise that race should play no role in our laws?
Well, in the redistricting context, this court has long recognized that legislators are always aware of race. And the fact that race was one thing they were considering when they drew the map does not mean it was the predominant thing. It means that it was one of many considerations that they had. Politics was another, communities of interest was another. And without some evidence that would disentangle those things and show that, well, actually race, among all of those considerations the state was considering, race was the one that actually drove the lines. Race does not, the plaintiffs have not borne their burden to prove that racial predominance.
Thank you, counsel. Justice Thomas?
In some of these redistricting cases, the argument is that a certain percentage of the black population is excluded, and you redraw the map to include that population. And what I'm interested in here is exactly what the violation was and exactly how this map solves that or addresses that violation.
So the violation was that the map adopted in 2022 dilutes the votes of black Louisianians by denying them an equal opportunity to elect candidates of choice. And the way we showed that was through drawing illustrative districts that included this common core of 7 parishes in the center of the state and connecting that with populations in the Delta, which was a similar configuration to the state's map. So ours was sort of a least change map that would remedy the dilution. The state included that same core, and it drew together other different black populations in the district to create a remedial district that would remedy the dilution. And I think in that sense, this case is most like Abbott. In Abbott, the Texas court had held that there was a Voting Rights Act violation and the state needed to add additional majority minority districts. The way the state did that was that it drew together some voters in that Southwest Texas area where the violation had been proven with other voters in
which is gerrymandering.
And this court said that was fine. They did it for incumbent protection purposes.
It's a convoluted case.
The fact that it was the least compact district in the state was not even part of the analysis. Because the state had the flexibility to remedy that violation in a way that also advance its political goals.
Justice Alito?
Oh, let me ask you a question about illustrative District 5 that was before the Middle District of Louisiana in the Robinson case. So that district combined black populations near Baton Rouge and Lafayette in the southeast region of the state with splotches of black populations near Monroe, Bastrop, and Tallulah in the far northeast corner of the state. Now, how can the failure to combine these far distant populations in a map, in a single district, be regarded as the cracking of a concentration of black voters?
Well, the district court recognized that our illustrative maps were more compact, split fewer parishes than the state's map in creating a new
Yeah,
majority
the
black
maps,
district, and that is the
map scored well on those criteria, but how can that be regarded as cracking?
those
ISB.
populations, the way the effects
Louisiana
test under Section 2 works, and
v.
again, I would
Calais,
those determinations are
let me get the backgrounder.
were made in the
I'll pin it.
middle
I'll
district
drop it
in
again.
litigation that the state chose not to appeal. So those have not been part of this litigation. But to answer your question, the way the effects test works is it looks at the way the map is drawn and whether it could be drawn differently so that it would not have those dilutive
Okay,
impacts.
Yeah, I understand that. Now, not only are these populations distant from each other, isn't it the case that they differ in some fundamental respects and therefore may not be part of the same community of interest? The concentration near Baton Rouge and Lafayette are people who live in urban areas. The people who are way up in the northeast part of the state live in rural areas, small towns. Their values may be quite different, much more religious perhaps than the people down in the other part of the state. Isn't that true? And just one last question. Doesn't voting in the 2024 election substantiate that?
Your Honor, the district court looked at the evidence of the shared interests, and the district court in Robinson looked at the evidence of the shared interests among these communities that were drawn together in our illustrative districts. That was part of the evidence that we put on. The court heard testimony from lay witnesses. The court heard testimony from
there's
expert
that
witnesses
for butterflies.
about how they identified
The American the Heritage Foundation thing.
Drew the maps. And so the court made a determination that there were shared interests among the black voters that were in that district and that they would be advanced by having an opportunity to elect a candidate of choice.
All right, thank you.
Justice Sotomayor?
The problem I see is that Louisiana's original 2022 map does exactly what Justice Alito is saying, is joining together white voters who don't necessarily have shared interests.
Well, Your Honor, it is a similar configuration. So it's it does extend from the Florida parishes in the southeast and then wrap around the ankle of the boot and head up to the delta. So it's a very similar configuration.
That's the point, which is what you've done is tie together communities of interest in a different way, correct?
Absolutely, Your Honor.
And one that complies with Section 2 but keeps your political needs.
Exactly, Your Honor, and that's what the district court in Robinson found.
Not your political needs, but
Sorry, the sound from the source is going down.
If I understand the questions a couple of my colleagues are asking about, it's really was Robinson right, not was the decision below right. And as to whether Robinson was right, do you think that we're well positioned in this case to address that issue?
I do not, Your Honor. The Robinson decisions were appealed to the Fifth Circuit.
6 different Fifth Circuit judges.
Yes, there was a stay panel that looked at the merits and found that the state was not likely to prevail in the appeal, and then that was borne out by the merits panel that agreed that the district court had correctly found.
We had the opportunity to do something about it at one point. We let it go. 6 circuit court judges. As I understand the respondents' argument in this case, the respondents are not standing here. I mean, they might think Robinson was wrong, but their brief is not premised on the idea that Robinson was wrong. Is that correct?
That is absolutely correct, Your Honor. The merits of the Robinson decision have not really been part of this litigation at all.
Yeah, and the general here was saying, look, they litigated Robinson a lot. They took it to the Fifth Circuit twice. They litigated it a lot, and at some point, a state takes its loss and decides that it has to get on with things, and that's exactly what the state here did.
Absolutely, Your Honor. The state was not in a position to simply ignore the Robinson rulings. It was not in a position to draw another map that would dilute the votes of the black Louisianians whose rights had been violated.
And that's a reasonable thing. I mean, if we say all the time, states have to have breathing room. States have to have breathing room. This state used its breathing room to say, After we litigated this, and then we litigated this again, and we knew we
Yes,
were going to
Kathy.
lose because 6 Fifth Circuit judges had told us so, it was time to get on with things and draw our map that served our political objectives.
Absolutely. That's exactly what breathing room provides, that kind of ability for states to take those political calculations into account.
Thank you.
Justice Gorsuch. Justice Kavanaugh?
2 questions. One, a general equal protection question, and then a more specific Section 2 question. On equal protection law, we've of course said, and the court's long said, that race-based remedial action must have a logical endpoint, must be limited in time, must be a temporary matter, of course, in school desegregation and university admissions. How does that principle apply to Section 2?
Your Honor, I think that Section 2 is, the way that as it has been applied through Jingles, is tied to current conditions. It requires a totality of the circumstances analysis that looks at current conditions. It looks at racially polarized voting today.
Hi, Val. Hi, sweetheart.
Examples of discrimination today. So it's tied to current conditions, and there doesn't need to be an artificial time limit on how Section 2 would apply, because it's always applied based on current conditions.
And second, on the specific questions here on the race politics, I just want to disaggregate this. My understanding of your position is that the reason that there's a second majority minority district required is because of race, because of Section 2. But the choice between which majority minority district to use was made entirely on politics. Is that your position?
Yes, that is our position.
Thank you.
Justice Barrett?
So is your understanding of breathing room, I just want to be sure I understand your answers to Justice Kagan, is your answer to Justice Kagan, your understanding of what breathing room allows a state to do, necessarily mean that anytime there's a district court order finding a Section 2 violation, that is reason for a 14th Amendment claim to then later lose? Because compliance with Section 2 would always be a reason for the state to draw a race-based district.
Your Honor, absent some unusual circumstance like collusion, a decision by an Article 3 judge provides about the best reasons that a state can have for thinking it faces Voting Rights Act liability. It's been adjudicated to have likely violated the Voting Rights Act, and this court has said good reasons means that there is the state has good reasons to believe it faces Voting Rights Act liability. So yes, I would say that when there is an Article 3 judge's determination, in this case affirmed by the Fifth Circuit, that's about the best reasons this court has recognized as requiring remedial action.
So let me follow up then on Justice Kavanaugh's question. He pointed out there's 2 steps here. One, you had to draw a second district based on race, but the shape of that second district was based on political considerations. What if that wasn't the case? What if they didn't like the one imposed by the Robinson map, your map, and said we're going to draw a different one, but expressly said the whole time, didn't talk about the speaker, didn't talk about anyone else, didn't talk about politics, just said we're doing this because of race, we don't like that other map, race, race, race. So the shape of it was also based on race. It was just different than the other one.
Well, I think part of the strict scrutiny analysis is that you have to look at, was race used in a way that wasn't necessary to comply with Section 2. So if they used race and they packed black
It's
voters
Teresa's birthday, and new friend Tanya has a birthday tomorrow.
partisanship through race,
It's a birthday month.
That might render it invalid.
So that would be an example where you couldn't just point to the earlier Section 2 litigation as the compelling interest.
No, Your Honor. It is the compelling interest. The question is, in remedying the violation, did they use race in a way that wasn't necessary to remedy the violation, and they used it for some, other illegitimate purposes?
Okay, thank you.
Yeah,
Justice Jackson?
Yeah, just to follow up on Justice Barrett's point, your point is just that the previous litigation provides the compelling interest, a good reason to go forward, but there's still always the narrow tailoring, and we're looking at what it is the state is actually doing with respect to its remedy, right?
Yes, absolutely.
Has the court ever held that race predominates whenever a state draws a district to comply with Section 2. I thought we suggested the opposite in Shaw v. Reno.
This court has not held that. The court has expressly said that intentional creation of a majority-minority district does not on its own prove racial predominance. That court said that in Bush versus Vera, and then in Bethune-Hill, the court refused to find predominance even where the state had a 55% target. That was just one consideration in the predominance analysis. It wasn't the whole analysis.
And is it the plaintiff's burden, the plaintiffs in the equal protection case, burden to disentangle race from politics in a case like this?
Yes, of course. It's the plaintiff's burden at the first stage on predominance.
Thank you.
Thank you, counsel. Mr. Grime?
Mr. Chief Justice, and may it please the court. With one exception that we'll get to in a moment, there is nothing new or extraordinary in the fact pattern presented by this case. This is Shaw 2 again. This is Miller again. This is Bush v. Vera again. From the very beginning of this court's racial gerrymandering jurisprudence, it was born in an era where states were drawing majority-minority districts allegedly in order to comply with the VRA, whether it was DOJ pressure under Section 5 or fear of Section 2 liability. In Shaw 2, the District 12, the unusual district in North Carolina, was not drawn where DOJ wanted the second district to be drawn. It was drawn there to protect Democratic incumbents. In each of these cases, that the state always says it wants to protect incumbents. And that's why its district is not quite the same as DOJ wants or as the plaintiffs in Section 2 want. So there's nothing new about that in this case. What the appellant's claim is new is Robinson. But Robinson was not a final decision, and we can avoid all the problem about how final it was or how convincing it was by simply asking the defendant on strict scrutiny to bring this mountain of great evidence into the court and show why there's a strong basis in evidence for drawing a second district and to show why it's narrowly tailored. But ultimately, they didn't do that here because this decision is badly flawed and because the district judge in Robinson at page 834 looked at the original Hayes slash map, which is so close to this map, and said that the districts there were diffuse and nonsensical. And so that's why it never came up, and that's our problem here. I'm happy to answer questions.
Do we have to accept Robinson, which is not on appeal here, as a given?
Justice Thomas, we don't have to. Instead, we should have looked to the defendants to bring out the parts in district court about Robinson that they thought were so compelling, and they never did. They actually tried to block any discussion of Section 2 at the district court level.
I'm sorry.
No, go
ahead. They have a decision by a lower court that they're likely to succeed. They have an appeal of a temporary restraining order where that court says they're likely to. And we have a merits panel who looks at it and says they're likely to win. They can't.
Oh no, Max Flower, delete any 23andMe. They're going bankrupt.
That they need to comply with Section 6.
Check out the California Attorney General on that.
First of all, if they did believe that, the answer, so that we wouldn't have to speculate here, would be bring the evidence to the three-judge district court.
Why did they have to do that? Meaning what you're asking for is a relitigation of Robinson in total. Well, but it's not whether they were right or wrong. We've said that. Good faith doesn't mean that you're proven that you had to do this. It's just whether you had a good faith basis to believe you should do it.
But in Wisconsin legislature, this court said that the breathing room is for reasonable mistakes in the data, but you have to make your showing. You have to make your showing.
We'll go back to that. Thank you.
Well, counsel, can I just ask you, because some of the things that you've said makes it seem as though you're suggesting that Louisiana's pointing to the court order was pretextual. In other words, you say if they believed that the court was ordering them. So do you have some basis for disputing what Governor Landry said? We are here today because the federal courts have ordered us to perform our job. We have exhausted all legal remedies, and we have labored with this issue for too long, and that's why we're drawing the map. I mean, do you concede that Louisiana at least sincerely believed that the courts were requiring it to do this?
Well, I think I would simply point to the litigating position of Louisiana throughout the case, including just a few minutes ago. I mean, in their heart of hearts, they don't believe the VRA requires this.
No, I understand. They thought the courts were wrong, but the question is, did they believe that a court was ordering them to do it? I mean, I am sort of concerned about your view, as seemingly expressed, and I want you to clarify it, that a court order compelling you to do something is not a good reason for you to do it.
Justice Jackson, I'll just fall back on General Murrell's comments to the legislature, making clear that the state was not under a court order at the time. Instead, the Fifth Circuit said you can either go back and defend this district without using your Allen v. Milligan style theories and actually put in evidence on the Jingles factors, which they hadn't done, or you can go draw a VRA compliant map. They were not ordered to simply go draw a
No, but that
new
goes
map.
to the remedy. I'm asking about the violation. We had many judges, as other justices have set forward, that looked at the actual merits of the question of whether or not there would be a VRA violation if a new map wasn't drawn. So Louisiana felt, I think they're saying, compelled to do something about this. And you seem to be questioning whether or not they were, and I'm just trying to clarify that.
Well, I mean, at the end of the day, we do have to take Louisiana at their word. But I just want to be clear, they were given a choice to actually go in and raise a defense. And I think reading Robinson makes this clear. The court says time and again, Louisiana, you raised the Alabama arguments from Allen v. Milligan. You tried to use experts to show that Jingles 1 was violated because of the intent of the illustrative map drawers, but you never put in actual evidence on the types of factors that Justice Alito was talking about.
I guess I don't understand, Mr. Grime. Like, what should Louisiana have done? Louisiana litigated this case. It lost in the district court. It lost twice in the circuit court. You know, if I read the list of the judges, I'm just going to tell you that if you lose those judges, you're going to lose. We had no interest in taking the case. It was brought to us. We said no. What was Louisiana supposed to do?
Well, I think in this case, the Fifth Circuit laid out the options. I mean, first of all, Louisiana had no reason to think. I mean, the same illustrious list of judges pointed out that you can start over again. You can retool and maybe don't use Allen v. Milligan as the roadmap this time. I mean, that hint was clearly given to the state. And
so I guess I get the idea that it did have the option to keep on finding ways to litigate this question. But there were ways that it could have refused to give up. I take that point. But at some point it said, you know, we've
emergency docket. Oh, sorry, I'm so loud. Emergency docket, Val.
And we're going to accept that, and we're going to move on and find a map. And then the state lawyers come in, and I mean, the record is like the state lawyer says, there can be no better reasons to believe that the VRA required a second majority black district than a precedential opinion of the Fifth Circuit affirming that a map with a single majority black district likely violated Section 2. And the state lawyer talks about all the process that they went through and the hearing that they had and the maps that were submitted. And she says, what better reason could there be for this? So, like, at a certain point, like, I get that there might have been other options, but that's the whole point about breathing room, right? Breathing room is states have choices. And this was one state that decided on this choice that you don't agree with, but it was like well within the parameters of like a good faith, reasonable choice.
Justice Kagan, if that were true, then what the state should have done is brought that before the district court. What the state argued in the district court is that Robinson's mere existence was dispositive, that we were essentially stopped from even bringing our claim for that reason. And so if the evidence was so compelling in Robinson, all they had to do was use their trial time. They didn't even use all their trial time and show us the key points.
Counsel, you know, if we're going to defer to the Fifth Circuit, they also found a constitutional violation here, too. So they're speaking out of all sides of all mouths down there. I'm not sure that's how the system works anyway. But I have a question for you on the remedy. Your friends on the other side say, okay, race predominated in creating a second district, but race didn't play a role in this squiggly line district. It was politics. And I want to get your response to that.
Sure, there are two responses, Justice Gorsuch. First of all, Senator Womack, in his presentation, he's the sponsor of the bill, said there is just not enough black voter population in southeast Louisiana, and he says that is why the district is drawn up to Shreveport, up I-49 and up the Red River to Shreveport. So the sponsors were very clear that that's what they were doing. So you can look at the evidence, but the other issue is this. The only reason that politics began to matter at this level was because they accepted that there had to be a second black majority district. That then caused the problem of losing an incumbent and having to choose who was going to be lost.
What does it mean to say race or politics predominate? I mean, I thought the 14th Amendment said we don't look at race. Predominate says you can up to a point, but I don't know what that point would be.
This guy is such a dick.
And I don't know, can two things predominate? Can politics and race predominate? I don't know.
Justice Gorsuch, that may be a problem in some racial gerrymandering cases. It's not a problem here, though, because everyone admits that step one of the process, in fact, the state admits in its briefing, the baseline was to draw a second black majority district. Everything else that happened, flowed from that. And that's enough under Bethune-Hill, under Cooper, under several of the court's cases.
That's enough for predominance? We have a case that says that if you are drawing a second or third or whatever black minority district, you satisfy the racial predominance?
What I was quoting was that the standard for predominance is the initial decision that couldn't be compromised. And actually
then there's no way to comply with Section 2.
Well,
if what you're saying is you can never, a state could never in good faith redraw a map if it believes that it's going to draw a map that is going to solve a Section 2 violation. That's what you're saying.
Carla, I missed you. Oh, man.
Sotomayor, they would then show on strict scrutiny a strong basis in evidence for drawing that map. And so, and that's what, that was shot too.
But that's what they've done here. They've got a judge saying, you've violated it. There's an alternative map that meets all traditional criteria. Go draw your own map, but make sure you get a second out, because that's the only way to remedy this violation. And they come up with a second map or a different map that they show is based purely on politics. They wanted to save 3 incumbents, so they drew lines to save 3 incumbents.
Justice Sotomayor, I think it is helpful to look at the remedial map. I mean, first of all, Senator Womack stated that it was for the purpose of capturing additional black voters that it was drawn that way. But we can skip a lot of the difficult issues that have been raised here by going to one point. And that point is from Shaw 2, from Miller, and from Bush, and actually in LULAC as well, which is that you can never have a Section 2 remedial map that fails Jingles 1. That is not geographically compact and does not comply with traditional redistricting criteria. And that's what the district court found here as a matter of fact. We have a factual finding from the district court on that point.
Well, their answer to that, I think, is the 70%. So can you just address that?
Sure. So the 70% does not trump the geographical compactness requirement. I will address that, but I want to make very clear that no matter what, even if you've
covered a lot of the old population. You can't draw a non-compact remedial district, and that decides the case. But the other problem is this. First of all, I think the correct number is something like 67%. We looked, but it's over half of the population. And that really matters when you're looking at jingles, because remember, jingles hinges on some very fine calculations. And when you lop off 100,000 black voters in 14 parishes, have to find 100,000 new black voters in another area of the state, you can't just assume that that's substantially related. The 20% issue also, if you go back and look at Shaw 2, the 20% they're talking about is Mecklenburg County. They're talking about the black voter core of that county. The court's referring to 20% of the area of that District 12, but we couldn't tell. We looked for this. You can't, it likely was a much higher percentage of the black voter population of District 12, but it's not in the record, and I've not been able to figure it out.
Counsel, speaking of the record, I have to point to what the appellants point to on page 18 of their brief. This is the state's brief. When they talk about Senator Womack, you've mentioned him several times, and apparently he was asked directly what was the predominant reason for you to create the 6th district this way, the way it looks now, versus just going with Senator Price's bill, which created a more compact district. And he answered, it was strictly politics. Politics drove this map because of the Speaker Johnson, Majority Leader Scalise, and my Congresswoman Julia Letlow predominantly drove this map. And he disavowed that race was the predominant factor. You've said exactly the opposite several times here. So can we just get some clarity on what Womack's position was?
Sure. First of all, Senator Womack said a lot of things. What I quoted from Senator Womack was accurate. But what Senator Womack was doing was distinguishing between the Robinson maps, or whatever one presumed them to be, and the new district. The problem, though, is that this court has never said that there is a second intent analysis done on strict scrutiny. In fact, Justice Kennedy, specifically in Bush v. Vera, said, in response to Justice O'Connor suggesting that that could be the standard, said we've never recognized that, and no case from this court ever has.
Let me put it this way. If Louisiana had accepted the initial Robinson map, would you have brought your litigation? Would you have been able to make the argument that this was not compact, this was somehow a violation, or what would your position have been?
Well, we don't have all the facts in front of us, but we would have scrutinized it, and if the record had been what it was in Robinson so far, we absolutely would have brought the case. And then they would have come into our case and said, well, we think it's compact. We only looked at plan-wide compactness, and that's why we won. I mean, I think we would have prevailed, but
I guess I don't quite understand the role compactness plays in your analysis, because, and this goes back to Justice Kavanaugh's point, that it's really sort of two steps. I mean, once Robinson has provided Louisiana with a good reason to think that there was a Section 2 violation that they needed to remedy by creating another minority district, once that happened, what Louisiana did was look at this map and say, essentially, we have 3 incumbents and we know which 2 are really important for the state to keep. And they created a map that made sure that they kept the 2 incumbents that were most important for the state to keep. And why isn't that completely within the prerogative of a state? That has nothing to do. I mean, it creates a less compact district, no doubt about that. But, we've never said to states, oh, you got to go with compactness when the Speaker of the House is going to be thrown out. I mean, it's totally within the prerogative of the state to say incumbent protection and particular incumbents are really super important to us.
2 responses, Justice Kagan. First of all,
That doesn't feel fair, though. I think I'm missing something.
Has racially gerrymandered black and white voters.
But there's 2 steps here. One is there good reason to think there's a Section 2 violation? Robinson has created the premise of thinking that there's good reason, that you need to create another map. Now the question is, what does that map look like? It's the remedial question. It's does the map substantially address the Section 2 violation that you have good reason to think exists? And the state says, The plaintiffs have presented these maps that would substantially address that. We have a better map that would substantially address that, that also allows us to keep our incumbent. Better because it allows us to keep our incumbents. I mean, what's wrong with that?
So
if the state can't do that, the state has no breathing room.
Well, first of all, we disagree with the first premise of the question, but here's, I think, where the problem is. This court is going to have to overrule Shaw II and Miller if it holds that you don't have to draw a geographically compact remedial district, because the court in Shaw II said, looking at District 12, there's no way we can find that there is a geographically compact population of any population of that district, and that is why that's why they lost in Shaw II.
I think this is a little bit backwards, Mr. Grime, because you will only get to evaluate CD6 if we find that there was good reason to think that there was a substantial likelihood of a voting rights violation. So that good reason is provided by Robinson, and Robinson says that there's a compact minority population whose Section 2 rights are likely being violated. Once Robinson says that, the question, only becomes whether CD6 substantially addresses that Section 2 violation. But the compactness inquiry, which is is there a compact district such that Section 2 is being violated, that happens at the first step of the analysis, and Robinson has already addressed that question.
Well, but unfortunately, Robinson is addressing a different area of the state, and that's the problem. That's why compactness is a backstop. The other problem is this. In states where you are wringing out the very last elements of black voting population, it's inevitable that whatever the gerrymander is that's finally drawn is probably going to have some fair slice of what was in the original maps. That's why if you only focus on overlap, you're missing the key issue from Shaw II and from Miller, which is that you have to have a geographically compact remedial district, full stop. And that's the backstop that keeps us from having to draw lines and figure out how much of Mecklenburg County was really in each district, and whether 67% and over half the territory is enough. And again, it matters because these are jingles districts, and all we know is the average for the whole district. We don't even know that the section we're gathering combines with the new voters to satisfy jingles.
Maybe I'm missing the thrust of the question, but the question seems to be, is it not the case that if you grant the premise, then on the at the remedial phase, anything goes? Now, can that possibly be correct? Suppose that the district that's created is not, the parts of this district are not even connected. You've got an island here, an island there, an island here, an island there. Would that be okay?
Absolutely not, and that's the problem.
Mr. Grime, it is not an anything goes inquiry. We've said it has to substantially address the voting rights population. So, for example, where there was a remedial district that addressed only 20% of the people whose rights were actually violated, we, of course, struck that down. But here, the district addressed 70% of the people whose rights were being violated, which seems like a ways different from 20%, and seems to suggest that the voting rights the voting rights violation was being substantially addressed, which is the only thing we've ever required at that point.
But, well, actually, Justice Kagan, in Shaw II, the court says that the remedial district must be compact. It must hold a geographically compact population. And, why not just take Shreveport, skip the intermediate territory, and not have it be contiguous, and add that to what is claimed to be the core of this district? Now, again, it was the state's burden to show this in the district court. This argument was never raised in the district court. There was no evidence whatsoever in the record about how many of the people from the original district were in there, and whether by combining them with the new populations, we have anything that looks like a jingles district. Because again, their entire argument was the mere existence of Robinson completely satisfies strict scrutiny. That cannot be correct.
Your lead argument in the brief for why there was no compelling interest here in the race-based redistricting on page 36 was the durational point, the Constitution, the authority of a state to engage in race-based redistricting must have an end point. You haven't mentioned that so far. The other side said that that argument's been forfeited, and I want to get your response to that. The fact that you haven't mentioned it so far certainly supports what they're saying on that, but I'll give you a chance to respond.
Sure. I mean,
like beer.
With this case is that
I got to get that sound clip.
The appellees win many different ways. And this is an argument we're making on the side of the case that is the state's burden. And so I don't think the law supports that it's our duty to anticipate, second or third or fourth reasons why they'll fail under strict scrutiny and make sure we raise them below. And so I don't think I don't think the argument was ours to forfeit. I guess I can put it that way. But the problem is this. If you go back to Robinson, the evidence on current racial context in Louisiana that still requires this purely effect-based test was very thin. They could have actually.
That's a 24-hour meal. There's no time.
But they never did do that. Again, they didn't bring in any jingles evidence, let alone the kind of evidence that would say, if you look around Louisiana, there are still a lot of barriers to black citizens voting. So that's not in the record. I think there's a reason for that. And I think that shows us that Section 2 is no longer performing the function that it was assigned, that Congress thought it was going to perform back in 1982. Now, why are we seeing so many Section 2 cases? Why are we suddenly now, as voters are becoming more integrated, why are we suddenly finding new Section 2 districts everywhere? I think that's a problem.
Thank you, counsel. Justice Thomas?
Dr. Ford has described you as being intoxicated at a party. Did you consume alcohol during your high school years?
Yes, we drank beer. My friends and I, the boys and girls, yes, we drank beer, liked beer, still like beer. We drank beer. The drinking age, as I noted, was 18, so the seniors were legal. Senior year in high school, people were legal to drink, and we drank beer. And I said sometimes we probably had too many beers.
Raised again, we think we'll be able to show that it's not sufficiently compact, that there are far-flung black communities in northern Louisiana and even in the Delta Parish.
I'm going to make that a sound thing.
That don't have very much in common with the more dense population in East Baton Rouge. And I think we'll be able to show it doesn't perform as well, but
thank you.
Not in the record.
Thank you, counsel.
I like beer.
Rebuttal, counsel?
Exactly. Find someone who loves you as much as Justice Kavanaugh loves beer.
I would emphasize this court's decision last year in Alexander, where the court emphasized caution that when a federal court says that race was a legislature's predominant purpose in drawing a district, it accuses that legislature of offensive and demeaning conduct.
That sounds good, butterflies. Now I want seafood. I was going to say something else.
Are telling a state to use race to draw a second majority district. So, Justice Jackson, we don't think the court needs to get to strict scrutiny because race did not predominate under Alexander. Second, on the question of strict scrutiny, my friend talks a lot about Shaw and compactness, but respectfully, my friend ignores footnote 9 of Shaw.
I hate when they call each other their friend.
Shaw 2, this court said that even a plaintiff in a successful Section 2 case does not have a right to be in the ultimate remedial district that is drawn. That's because that footnote emphasizes a state has
Guinness has a good one. Harp. I used to drink that when I drank non-alcoholic beer. I don't drink that anymore.
To satisfy jingles in drawing the remedial
I love bitters and soda.
The third point is just one about next steps. With all due respect, we'd rather not be back at the podium this fall defending a new map against a new challenge. This court's cases promise breathing room. We operated in that breathing room in drawing District 6. And if this court holds otherwise, then respectfully, I don't know what this court's voting cases mean. We ask you to reverse. Thank you.
Thank you, counsel. The case is submitted.
Super. Thanks, everybody. Let's go ahead and just get into some news. But first, we're going to take you back to the campfire. I see you, Putin. I see you over there in the corner, motherfucker. Yeah, I'm going to have to get the, oh, is that it? I drank beer. Wait, hold on. Is that it? No, I don't think that's it. I think that's Obama. I don't get that. Oh, it's Obama. Thanks, Obama. No, I'm just kidding. So I will say a couple times, just to wrap up that SCOTUS case. It's a very complicated case if you read the backgrounder that I put from scotusblog.com or .org. SCOTUS blog has a backgrounder on this particular case. Sorry, I'm so, my mic is really hot. I'm so sorry. I hope I'm not blowing your ears out. There we go. Turn myself down a bit. So anyway, so from that SCOTUS case, it's a very complicated and convoluted case. And hot mic with beer is my favorite. So it's very it's difficult to take at face value. I would encourage everyone to do a little bit of the background reading to understand that case, and it's basically it's concentration on the Voting Rights Act and the anticipation that is about to be next on the chopping block in the destruction derby that is this administration. Burn it down and build it back in your own image and then charge a big-ass admission fee. That's really what's going to happen. Burn it down, swoop it up in the fire sale, get your money, and privatize it all, baby. Be my lord, I'll be your serf. But interestingly enough, yeah, that stupid motherfucker over there, Jane, that was a good one. Sorry, I missed that one. Oh God, sex video. What? Yes, Jim, I do remember when pizza and beer was a cheap date. Not anymore. Thanks, Obama. No. That's what we say to everything, so never mind us. But yes, I will, obviously, if you know me at all, you'll know that the description for all of the things that we read about today, those little links will be listed in the description of the video, probably by the end of the day. So in case you missed anything, any source document that came through the chat, I'll have those in there. Just a note. But I really want to turn our attention now to what is happening with ICE and immigration. I should have worn my Abolish ICE t-shirt today. I'll have to put that on. And I highly encourage everyone. I think it's never a bad idea. I think there's lots of cheap t-shirts on Etsy and things like that made by local people to you. So buy local and get a shirt that says something very spicy. Get spicy out there. Get spicy. And you know what? Yeah, okay, it might be a little slacktivism. I don't give a shit. You know what? I'm going to take all the activism. I'm going to take the slacktivism. I'm going to take the full-fledged activism. I'm going to take the hyper-activism. Okay? I'm taking it all. All right? Everybody's welcome. You want to talk about a big tent? Bitch, we have a big tent. That's it. So get your Abolish ICE shirt today. And send a message, right? You're sending a message to other people also in your community that says, I don't agree with these motherfuckers. I don't agree. And you know what? Sometimes people need to know that you don't agree with what the fuck is going on. That's right. So, that's it. So it's not, let's stop judging each other. Let's just get into it. Just fucking don't stop criticizing each other. Stop virtue signaling. Stop doing all that shit. Just do what you need to do. Just do what you need to do. I mean, I'm guilty of it too. I've been criticizing some people lately, like, where'd you come from? You know, that kind of thing. I'm done. I got to focus on my own shit. I got to do what I got to do. And if somebody's doing something over there, that's fantastic. You know, like, great. And if you're an op, then you better be careful, because there's people watching for ops now more than ever. And the game is up. So go ahead and op your heart out, but don't expect it to be a long-term success. That's all I'm saying. I'm not pointing that at anyone. I'm just saying that's what it is. Yeah, I'm not a fakeryet. You're a fakeryet. So fuck that shit. I don't care. You know what? Politics, fucking politics. That's the other shirt that I got for this summer. Fuck that. Politics was done on November 5th. Okay? Politics was done on November 5th. We're post-politics now, baby. Okay? We're post-politics. Yeah, go ahead, op your heart out. You bless your operational heart. Operative heart. Bless your operative little heart. Just fucking do you. You do you, boo. I don't care. I don't care. We got shit to do, and people are suffering. Because guess what? One of the links that I dropped is about the conditions in the Miami detention center that Jim brought to our attention. I haven't been able to find the direct quote about the deaths within that, but I'm not shocked to hear that. And so we've got the Miami situation. We've got Guantanamo, where there were people sent there. We had no idea who they were or why they were sent there or how they were treated when they were there. Those stories are starting to emerge. Then we brought them somewhere else, I guess, into the Miami detention center, which is now tragically overcrowded. Again, with people that we have no idea. Yes, I do. On locating, absolutely. Let me pull that up. I actually was looking at that. That was coming up. So, yes, thank you. Hold on, and I'll get you. I want to make sure none of these are like weird ass things. Okay, so, God. Okay, hold on. Now I've got a good source. I just wanted to make sure I got a good source here. Hold on. And people being sent to El Salvadorian prisons. Okay. No, I definitely want to share. Thank you for that reminder. Oh, wait, did you have something? No, you didn't interrupt at all. I did not read the Times piece this weekend yet. Okay. Hold on. God dang it. That's not helpful. Please. Come on, PBS. The Calibri Center for Human Rights, is that report a missing migrant? The Calibri Center for Human Rights promotes healing and change by working with families of disappeared migrants to identify and honor those who have lost their lives on the Mexican border. But it is, I don't know if that's overall. Okay, so that might be more around missing persons other than this particular. The International Organization for Migration. I've not heard of them. All right, I'm going to do my homework because I want to make sure that I give a good resource. But I did run across some resources for if someone is missing in your community, how you can help identify where they are and find out what's happening. And those stories are starting to emerge, which is important. And this is my real concern here is that while we argue about Democrat messaging while we while we worry about Tesla protests, whether you are for or against. Thousands of people are being removed from our communities, right? Neighbors, friends, family members, or they are living under constant fear. And we have epically, I mean, we've got Bush level obfuscation of who these people are that they are taking and where they're going and how they're being treated. But we can assume some pretty bad things given Nayib Bukele, who is the El Salvadoran president and simp of the administration, and all the shitheads. Matt Gaetz is his butthole buddy. I just fucking hate that guy. Then also wait. So like Matt Gaetz kisses his ass. What's his name? Oh God, I keep thinking like Larry Miller, but that's not his name. That's some Jason Miller. Jason Miller, all those guys, Don Trump Jr., they've all been up Nayib Bukele's ass, and now we're paying El Salvador to imprison people who were residents of this country and our neighbors and our friends. Yeah, what is that, Max? People at the border being questioned about their loyalty to an administration or their anti-administration social media profiles? Immigration officials now demanding social media profiles? How soon until an AI model will sift through everyone's web presence and give everyone a Trump derangement syndrome score? That's very frightening. And in addition to our neighbors and friends who are being removed from their daily lives for no reason other than very sketchy reporting from Tom Homan, who is going to be a whatever a peacetime war criminal is, that's what Tom Homan is about to be. I predict Tom Homan sitting in a courtroom with a gray face, waiting to hear his fate. It may not happen in my lifetime, but I predict that that's the level of butchery that will be pinned on Tom Homan in particular, and Christie. Well, I mean a crime against humanity. But I think it's going to be bad. And I know I'm stating the obvious, but I think it bears stating. In addition to that, you have, I think this was today from the New York Times. No, it was yesterday. Mahmoud Khalil, the student, the grad student from Columbia, who protested against ethnic cleansing in Gaza, which is his right to do, as is everyone's right to do, that they're trying to really find charges to bring against him because they know they have nothing. And so I'll read this article. Yeah, I mean, I really think Tom Homan is a very, very bad person. And I think he's going to prove to be everything we think he is and more, which is really frightening, frankly. Okay, this is the article. Let me get over here and then get over there and then get over here and then get over there. Get over here. You might have sent this to me, Teresa. I'm sorry, because you know what? You guys have been sending me stuff, and I'm an idiot. All right, so this is from yesterday. Oh, it's been updated. Okay. When Mahmoud Khalil, who helped lead pro-Palestinian demonstrations while a Columbia University student, was detained this month, the Trump administration argued he should be deported to help prevent the spread of anti-Semitism, invoking a rarely used law. Lawyers for Mr. Khalil, a legal permanent resident who is being detained in Louisiana. I think they've moved him to, are they moving him to New Jersey? Yeah, seriously, Chicky, you better be careful. That's true. Chicky. I love that so much. Lawyers for Mr. Khalil quickly responded that the administration was retaliating against their client for his constitutionally protected speech criticizing Israel and promoting Palestinian rights. Last week, the government quietly added new accusations to its case against Mr. Khalil, saying that he had willfully failed to disclose his membership in several organizations, including a United Nations agency that helps Palestinian refugees, when he applied to become a permanent U.S. resident last March. It said he also failed to disclose work he did for the British government after 2022. What'd he do? Did he work for DFID or something like that? The Trump administration appears to be using the new allegations in part to sidestep the First Amendment issues raised by Mr. Khalil's case. You know, that First Amendment thing. On Sunday, in a filing opposing his release, Justice Department lawyers, and I'm using that term very loosely, argued that the new allegations reduce the importance of concerns related about Mr. Khalil's right to free speech. Oh, did they? Because you guys said it. Quote, Khalil's First Amendment allegations are a red herring, they wrote. Given the new allegations, they added, there was an independent basis for his deportation. Really? Nancy Mace made a threat on her Facebook page to someone because they disagreed with arming Israel. She basically told that person it makes them an enemy of the state and can be jailed. They're really going nuts, okay? They're going nutballs. Oh, good. Gal, I wanted to talk about that too. The Judge Boasberg's update. Screenshot in Discord. Oh, thank you so much. At 1:30 ET, so 10:30, 2 hours from now about, Circuit Court of Appeals will hear an argument on whether to stay Judge Boasberg's temporary restraining order barring removals of alleged members of Trinidad under the Alien Enemies Act. Oh, that judge is getting mad. Yeah, the Bill of Rights applies to all persons within the U.S. jurisdiction, not only citizens. And, fun fact, he was a green card holder, so he's a permanent resident. Suck it. Okay? Oh, I don't know if I can take a heartbreaking one. Yeah, they're searching for a crime, and that should give everyone pause. That should give everyone pause. Chuds, talking to you. If you bought the line that the old Justice Department was weaponized, first of all, you're fucking nuts, because if it was weaponized, bitch, we wouldn't be here. Okay? If it wasn't we wouldn't be here. If they did their job, we wouldn't be here. So guess what? Not only did they not weaponize the Justice Department from the Biden administration, they didn't even do their fucking job. Okay? So shove it up your butt. All right? Shove it up your butt that you think somehow Biden's DOJ, which is also dumb because there was no connection between those two, except for the fact that they're both mediocre white men at this point. That, a weapon can be used ineptly. It can misfire. All right. So that's why we don't have any of the planners of J6 in prison. And by J6, I mean the insurgency that just won the presidency, by the way. So we've got that. And now we have a Justice Department who is literally searching for crimes in order to maximize punishment on someone who disagrees with them. What? Every chud should be in the street, standing up for Mahmoud Khalil's rights to protest an administration. Period. That's it. That's not lefty. That's fucking Constitution, bitches. Come on, all you first day auditors. You guys should be up in fucking arms. Anybody who's like pro 1A, freedom of speech, a freedom fighter for speech. Anybody who's doing that, you should be in the street for this man. You wake up. You missed the plot. You missed the plot. All the things they told you that Democrats and lefties were into and doing, all that shit is what they have always intended to do. And they did it out of the gate. And this time, versus 2016 and 2017, this time they weren't going to make any missteps. And so nothing that is happening right now, all the chaos, all the nonsense, that is part of the beautiful design. Because then when it all falls apart, the real leaders of the administration can step in, privatize the fuck out of it, and enjoy their lack of accountability and their unfettered access to the world's resources. So that's what they want. I mean, if you care about your children, if you, like, you're looking at future stuff and like, oh, I want a great future for my child. Well, then you don't want someone who's trying to create like a serfdom, basically, right? Traditionally, heritage were not monarchists. I know. But where are they now? I don't see Kevin Roberts being like, hey, wait a minute. I don't see Kevin Roberts complaining. I don't see Peter Thiel complaining. So it seems to me, by not complaining, this is pretty much working out in their favor to some degree. And I think from a Kevin Roberts, perhaps, maybe it's the control piece over, I don't know. That's a good question. I've asked that question myself because I'm kind of like, I'm scratching my head when it comes to the economy, and I've been doing a lot of like just, junior varsity kind of JV level poking around the economy and what's kind of like on the horizon. Yeah, the Heritage Office in Russia. And I think that it's interesting, like I don't know. I kind of think, wow, I wonder what Peter Thiel's thinking, or I wonder what Tim Cook is thinking. I wonder what, not Mark Zuckerberg, but I wonder what, I don't know. We know what Mark Andreessen is thinking. He just wants people to be oppressed. He doesn't give a shit about anything because he's got some venture capital to invest in this network state we call America. Which is really what, so it's money, money, money. It's so funny. Yeah, they want to live forever. Okay. And they want to live forever. They don't want to pay taxes. They want to sell you the products. They want to isolate. They want to take over other land so that they can just rape it from the resources. Or per the Mar-a-Lago Accord, they want to trade security. Like, we'll protect you if you, give us like amazing amounts of money. It's a protection racket. That's what America is going to become. And that's why they're literally forming like an external revenue service to take in money from the tariffs, so that what they're doing, and you'll notice Howard Lutnick and Trump, they're like, you're not going to have to pay taxes anymore. You're not going to have to pay taxes anymore. Oh, bullshit. You're going to be paid taxes on every motherfucking thing. everything, because it's going to be through the tariffing of other countries in exchange for us protecting or just not bombing the shit out of them. Literally. I'm not kidding. Friday, we're going to talk about the Mar-a-Lago Accord again and what's happened since then that is telling us and screaming in our ears that they've got some shit up their sleeve, which is why the human rights abuses and the fucking of the natural world and the destruction of what we think of as an economy and a privatization, those four prongs, that is what I am most worried about versus the Tesla complaints or the, any truth post. Yes, he announced a secondary tariff on Venezuela oil today. I saw that 25% tariff, I think. So, you know what? That's all the mishmash. All that stuff in front of us is like hiding this stuff, which is really the crucial, to me, fire alarm, which, thank God, we have good lawyers for Mr. Khalil, and they're on top of, what is happening and what this means and the 5-alarm fire that it really should cause. Hi, Karen. Good to see ya. So I want to read through this, and then I have a couple of other things too. So hold on. Don't go anywhere. Don't go anywhere. Khalil's First Amendment allegations are a red herring. Oh, okay, that's right. The new deportation grounds are patently weak and pretextual, said one of Mr. Khalil's lawyer, Ramzi Qasim, a co-director of CLEAR, a legal clinic at the City University of New York. That the government scrambled to add them at the 11th hour only highlights how its motivation from the start was to retaliate against Mr. Khalil for his protected speech in support of Palestinian rights and lives. Mr. Khalil's lawyers are fighting for his release in a New Jersey federal court. His wife, an American citizen who lives in New York City, is expected to give birth next month. The new allegations listed in a document from the Homeland Security Department include that Mr. Khalil did not disclose his work with a UN agency or Columbia University Apartheid Divest, a coalition of student groups that set off pro-Palestinian demonstrations at the school. And which I believe Apartheid Divest and other organizations like that on campuses have been around for a long fucking time. Mr. Khalil earned a master's degree from Columbia in December. The government also said that Mr. Khalil failed to list his continuing employment with the Syria office in the British Embassy in Beirut, Lebanon, after 2022. The efforts of Mr. Khalil's lawyers in New Jersey to secure his release are separate from the immigration court proceedings currently being held in Louisiana that could lead to his deportation. But in order to deport Mr. Khalil on the basis of new allegations, the government would have to convince an immigration judge that any failure to disclose the relevant information was willful and that it would have made a difference in his chances of receiving legal permanent residency status. The Trump administration is also standing by its original justification for Mr. Khalil's detention, citing a little-used law that says the Secretary of State can initiate deportation proceedings against non-citizens whose presence in the United States can reasonably be considered a threat to the country's foreign policy agenda. The Secretary of State, Marco Rubio, has accused Mr. Khalil of participating in anti-Semitic activities, referring to protests on Columbia's campus at which the Secretary said students expressed support for Hamas. Well, that's a stretch there, Marco, but okay. Fucking asshole. Mr. Khalil's lawyers have denied that their client promoted Hamas and have argued more generally that their client's speech is protected by the First Amendment. They are expected to challenge the constitutionality of the law Mr. Rubio used initially to justify Mr. Khalil's detention. Jesse Furman, a federal judge in New York who reviewed Mr. Khalil's case before transferring it to New Jersey last week, said that the First and Fifth Amendment issues raised by the case warranted careful review. Quote, the fundamental constitutional principle that all persons in the United States, constitutional principle, are entitled to due process of law demands no less. This is importante. Let me see what we got here. Oh boy. In case you missed it, this thread, infiltrators influence the strategic direction of a movement in several ways, often aiming to disrupt, discredit, or redirect its goals. Yes. And that is, listen, we talked about this at the lounge on Saturday. Yeah, but Nazi Musk is okay. At the lounge on Saturday, we talked about the fact that, within every, we just learned about the influx of kind of disruption bots, right, that are now on Blue Sky. Sorry, everybody. That's the way it is. Oopsie. That there's going to be a lot of attempts to wedge people and to divide and to influence action. Like, I put up something where I just shared Dave Troy's piece about the Tesla takedowns and the Tesla protests and how that was impacting Musk and all that kind of stuff. And it wasn't even it wasn't coming down on one side or the other. It was just informational. I shared it with a pair of eyeballs. Yeah, totally vulnerable. Right. And we knew it would happen. It's just a matter of when. And it came in with the Tesla stuff. So I had 2 replies from Democrats, which I don't know who they are. Big accounts or bigger followers. A lot of those follow back type things. But they're definitely not. But they came in with 2 very similar comments that were along the lines of, don't do anything to give, don't act like Republicans and be violent. That was one. Don't be like a Republican and be violent. The other one was, these protests just serve to discredit or something like that. I don't know. It was some kind of long little speech, but basically saying, don't protest Tesla. Seriously, Chicky, you better be careful. That's what they were trying to say. Thank you, Max. That's exactly it. And I'm like, what? I didn't even say I was going to do anything. I mean, I was confused at first, and then I put 2 and 2 together, and it's like, oh, well, I get it now. It makes perfect sense to me that there would be a bot farm of engagement that is trying to wedge and disrupt Tesla protests because Elon Musk is so fragile. So fragile that he can't stand the man has insurance for those goddamn dealerships, okay? He's not out anything. Nobody is out anything. Yeah, don't follow back. I'm not following back, really, anyone except for when I know you. Some rando wanted to argue with text on a pic of a sign I posted. Oh, really? Yeah, it's so there's a lot of fake, really weird engagement. I'm just ignoring it. Just ignore it, unless you don't want to. But it's not worth the energy. Just assume, okay, we're not too far away from full butthole shots on Blue Sky. Never match wits with an idiot. Exactly. Yeah, don't bother. It's all whatever. So, but it did take me by surprise. I'm like, what the fuck's going on here? This is so weird that I'd get 2 comments in a row from something so innocuous. But anyway, that's the way it is. Welcome to the internet, ladies. Let me see. What do we got over here? Oh yeah, this is a good one. I like. Yep. Creating internal divisions. Yeah, so this is a good thread Gal has on Blue Sky about about that interaction thing and what's happening. Let me see. Oh, I do want to show you this because he doesn't want it shown anywhere. So I really would like to just show this on air. I'm told butthole shots is how Blue Sky started. Caping. No. Yeah, sorry. You know how I'm about butt jokes. I love butt jokes. Noam is going to visit El Salvador prison this week. Does she have a prison guard? I'm sure she will. Where is she ordering those from? I just want to know. Is it like a Lara Croft cosplay outfit? That's what I'm thinking. I'm up to 5 views from a post on 3 days ago on Twitter. Woo, baby. I don't ever get you guys like stuff sometimes that I put on Blue Sky. People share sometimes. I don't have a huge amount of engagement on any interactive. But anyway, let's look at the picture that Trump absolutely fucking hates. Oh. Oh. Oh my God. Sarah, well done. Sarah, I love it. I love it. Oh my God, I love it. Purposefully distorted. Nope. If anything, it makes you look human. I mean, in terms of your skin color, that's more human. It's got your little clitoris right there. That's good. I think it's a perfect rendition. In fact, it gave you more hair. Look at how much hair he has. Look at the rosy cheeks. No, this is actually very flattering. Yeah, can you say the Streisand effect? I think that's very flattering. Very flattering. I don't know. Anyway, I just thought we should show that, on our little corner of the internet. Let's see. Oh, this. Okay. So, this is another gal share. Speaking of which, this is happening today. This is wonderful Roger Parloff from Lawfare. We love ourselves some Roger Parloff, that's for sure. A missing bullfrog sack. Oh, it is missing the bullfrog sack, yeah. But it does have the clitoris. Yeah, fat ass Trump, gals hashtag. Fat ass Trump. Fat ass Trump. He's a fat ass Trump. He's a fat ass Trump. I have a ton of horrible pictures of me on the internet. Get over yourself. Teresa, I wonder if Noam will jump back and forth in a jail cell. I'm free. I'm an illegal alien. I'm free. I'm an illegal alien. Neil. Look at me. Look at me. Look at me. Look at me. With her Amazon hair. I have Amazon hair. I'm not coming for anybody. I'm just calling them as calling balls and strikes. All right. So anyways, happening today, the upcoming Court of Appeals argument in the Alien Enemies Act, which is trying to stop people from being deported. The essence of this administration is just continue breaking the law. It's really Facebook. Okay. If you went to the Facebook offices in Mountain View at any time and you went to the reception area, if you're going to have a meeting with someone, there's a thing behind the fucking reception desk that says move fast and break things. And that has always been fucking this administration's mantra. Move fast, break things. So that's why the law, as much as valiant lawyers are standing up for freedom and trying to fight these abuses of constitutional power and illegal actions in many cases, they are hamstrung a bit by the fact that they follow the law, and that this administration is fully committed to just moving fast and breaking things because they know that at the end of the day, there's a SCOTUS that is willing to backstop whatever they do. So for those who may not have been thinking of it in that way, do you now get it? Do you get that that's what, and that's not, you don't want a government that does that. I know some of you think you do, but you don't. You don't want that. Okay? You don't. And it's really time to triage. Okay? It's time to look at and take stock of what you're activisming on, and take stock of where your activism is actually going to make the most impact for your current situation. So if you're being bothered about freedom of speech, well, welcome to the party, because I have definite actions that you should be very, very concerned about. I'm just saying. Put your money where your mouth is. Reprioritize. We've got houses on fire that need to be put out. Because if those houses burn down, it doesn't matter what's happening over here for us as in our lives. It doesn't matter if the popo are after us, or if a cult is after us and trying to stop us. It doesn't matter, because if these other houses burn down, that's a precedent for these smaller cases to be not decided in your favor. So I would really take stock and prioritize about what is important in this world, and realize that it does impact you when there are people who are removed for being alleged members of Tren de Aragua. Forgive me for not saying that right. That's the peak. That's the peak of despotism. That's the peak of authoritarianism, and that's the peak of a government tyranny, a tyrannical government that you all were so concerned about under other administrations, which, fair, but in relative terms, we're in a worse place. That's true. The Supreme Court cannot take all the cases. Some rulings will stand at the appeals court. Yeah, that's true. I hope the right ones do. He does look chubby in the picture. True. Funny how sensitive he is about one image, but not at all about the judgment of history. Now, traditionally, the Supreme Court also has not been comprised of monarchists. I know, but didn't they just kind of set a precedent that there is immunity for official acts, and there's, here's one thing in our favor, or in the favor of humanity. One thing in the favor of humanity is the DOJ lawyers are inept. Well, not inept, but pretty inept. I mean, Todd Blanche, Pam Bondi, you don't have the brightest and the best. I'm sure there's really great lawyers working for them. I'm sure they're having a really hard time with some of this. I'm waiting for them to raid libraries and take history books about blacks, Latinos, etc. I put nothing past I completely understand. They are erasing entire groups of people from the online history and codifying, which is a good segue, butterflies, because I do want to talk about this week. We're going to watch a couple of hearings where they're going over pending legislation. And those, while they are somewhat tedious sometimes, those are important. And why they are important is because they are codifying into law through these amendments and through these pull downs, right? This legislative pull down of agencies and services. Okay, they're doing that behind the scenes, and it's not behind the scenes because it's open record. But the distraction is the Tesla. The distraction are all these very important, actually, other things that are happening with deportations and imprisonments and overcrowding and fear mongering. But meanwhile, the Congress is busy unwinding regulatory protections, codifying, taking all the tear down that Doggy has been doing, all that tear down, all that damage, they're putting it into law. They're eradicating protections for the environment, and not not ones, I mean, I don't understand people that are like, oh, why do you want to protect a little bird? You know, I don't get that, because I do understand that there's an ecosystem, and there are actual ecosystem scientists that I'm not one of. And I think it's good if we figure out how to preserve our ecosystem. That's not a problem to me. I mean, you can argue fine points of regulations if you want, but that's not what you're doing. You're just removing regulations. So that's a different thing. Don't, kiss me while you're fucking me, okay? Don't. Sorry. I'm sorry. I'm really angry. Yeah, but merit, not ecology. That's right. The Sun, frankly, a trashy UK tabloid, true. Sun is the Sun a Rupert Murdoch production? Had an unsourced story saying King Charles could invite the U.S. to be an associate member of the Commonwealth. I suspect it's I think it probably is, Neil. I don't think Prince Charles wants to be anywhere near Dumpy Dump. I understand he invited him, but I think that was just a flex. I think he was flexing and saying, yeah, come to England because I'm the fucking king, motherfucker. Don't you wish you were me? That's what I think. That's what I'm hoping Charles is going to do. I'm hoping he just has like a total like, I'm a king and you're not. That's what I'm hoping. Come on, Charles, get petty. Come on, be a petty bitch. Please. We need it. We need you. All right, here we go. Let's see. At 1:30 p.m. today, which is 10:30, which is an hour and 15 minutes from now, the U.S. Court of Appeals that would vote no to U.S. in the Commonwealth. I know, boy, we really pissed off the Canadians. Let me tell you, you guys got pissed off super fast about that. I mean, I don't blame you, but it was kind of like, you're definitely like, okay, don't make a joke about the fucking Canadian thing, okay? At 1:30 p.m. Eastern today, March 24th, the U.S. Court of Appeals for the District of Columbia will hear arguments on whether to stay. He does. He knows how to be a benevolent monarch. He also knows how to take the piss out of somebody. I think. I'm pretty sure. Yeah, don't piss off the Canadians. My goodness. Like honey badgers. It's like a whole country of honey badgers up there. Currently barring summary removals of alleged members of Tren de Aragua, a Venezuelan criminal gang under the Alien Enemies Act of 1798. The argument is not about the matter in the case that has understandably most transfixed the nation, whether the Trump administration boldly defied that order moments after it was issued at roughly 6:50 p.m. on March 15th in the middle of a hastily convened hearing. Chief U.S. District Judge James Boasberg orally ordered Department of Justice Attorney Drew Ensign to inform his clients immediately to stop removals under that act, including by, if necessary, quote, turning around a plane. That order was not followed. Two planes, which appear to have taken off after the TRO hearing began, but before the oral order was delivered, continued on their way and eventually landed in Honduras, according to multiple media reports. Then they apparently took off again and early the next morning landed in El Salvador, according to those same reports. While the government's compliance or noncompliance with Boasberg's oral order is very much a live issue, on Friday, Boasberg vowed, quote, I will get to the bottom of whether they violated my order and who ordered this. Today's appellate court hearing is about other matters. It's about whether Boasberg has jurisdiction to issue that order, which was actually, as we'll see, two orders. First, let's step back and review the basics. On March 15th, the Trump administration unveiled a proclamation invoking the Alien Enemies Act against an invasion, quotes, by Tren de Aragua. In 237 years, that act had only previously been used when there had been a declared war, specifically the War of 1812, World War I, or World War II. Still, by its terms, the statute does say that it can be invoked in the absence of a declared war if there has been an invasion, quote, or, quote, predatory incursion by any foreign nation or government. Quote, whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the U.S. or any foreign nation or government, and the President makes public proclamation of the event, all native citizens, denizens, or subjects of the hostile nation or government, being the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. Ugh. I don't like that. You mean we haven't fixed that in all these years? I mean, I get it. I'm actually excited about what empathic people can build through the destruction that we're currently experiencing. I'm actually hopeful that we really are on our way to a better. So if you were a burn it down person to build it back up better, I'm in. I'm ready. Let's do it. Let's do it. Which I know people are doing. Let's see. To finesse those questions, the proclamation makes certain findings. It finds, for instance, that Tren de Aragua, I don't know why I can't say that, Tren de Aragua has unlawfully infiltrated the United States, that's in quotes, and that it conducts, quote, irregular warfare here. Further, it is closely aligned with and indeed has infiltrated the Maduro regime. Over the years, it continues, Venezuelan authorities have ceded ever greater control over their territories to various criminal gangs, including TDA, which has made Venezuela a hybrid criminal state. Ah, there's the state. The proclamation then purports to permit Trump to summarily apprehend and remove anyone it deems to be a member of TDA who is more than 14 years of age and not actually naturalized or lawful permanent residents, again in quote, i.e. not citizens or holders of a green card. Though the proclamation indicates on its face that Trump signed it on March 14th, it was initially kept secret. The Alien Enemies Act requires the proclamation to be public. After lawyers for the American Civil Liberties Union and Democracy Forward learned that the proclamation was in the works, they filed a suit seeking a class action status in the early morning hours of March 15th before the proclamation had even become public. By then, 5 of their clients, who are Venezuelans detained in the U.S. who deny being TDA members, had already been abruptly removed, they allege, from various detention centers around the country to El Valle Detention Center in Texas. This process began on March 8th or 9th, according to the complaint, and in some cases, it prevented the plaintiffs from attending scheduled asylum hearings. Interesting. The clients, and perhaps other sources, were telling the plaintiffs' lawyers that they were going to be flown out of the country within hours, if not minutes. The 5 plaintiffs were permitted to file pseudonymously identified only by their initials. The caption is JGGV Trump. In this crisis context, Judge Boasberg issued by minute order around minute order or minute. I think it's minute, right? Lolo, the law seems to talk about things like when the White House was burned in 1812. Yeah. Well, I mean, whatever. We're not in 1812. We were supposed to have learned since then about how to treat each other. That's my point. Okay. Barring the removal of 5 named plaintiffs for 14 days. It was intended, he explained, to allow time to at least hear the dispute. The Trump administration immediately filed a notice of appeal. At this point, the proclamation still wasn't even public. It would not be made so until 3:53 p.m., about an hour before the 5 p.m. hearing on the restraining order that Boasberg had set. On Friday, Boasberg expressed some wonderment about why the proclamation ostensibly signed on March 14th was kept secret. Mr. Ensign, the government is complying with the law as it understands the law to be. The court, exactly, I guess, and maybe you don't have the answers to this, but what's concerning to me is, if that's so, why was this proclamation essentially signed in the dark on Friday night or early Saturday morning, and then these people rushed onto planes? I mean, it seems to me the only reason to do that is if you know it's a problem and you want to get them out of the country before suit is filed. Can you tell me a little bit about the timing of this? Mr. Ensign, Your Honor, I don't have knowledge of those operational details. I'm just a girl. A strange additional issue has arisen since briefing before the appellate court was completed on March 22nd, Trump told CNN, I don't know when it was signed because I didn't sign it. It's unclear how this assertion might impact the case. Sign what? Sign what? Yes, the makeup artist who's, oh God, I'm just making me sick to my stomach. The people that are, it's just everyone deserves due process. That's another thing that people should be in the street for. If you're so concerned about government overreach, you should be in the street. Me too. To stop this from happening. This should be the most important thing. Right? I think. I don't know. All right, here we go. During that same initial hearing on March 15th, sometime after 6 p.m., Boasberg said he was provisionally certifying of all non-citizens in U.S. custody who are subject to the proclamation and barring their removal, all non-citizens in U.S. custody, barring their removal if it was being accomplished solely on the basis of the Alien Enemies Act. After the hearing, Boasberg issued a written minute order memorializing the rulings, and the government immediately appealed that. Also, just this morning, today, Boasberg issued a 37-page ruling declining a government motion to rescind his orders. So in today's proceeding before the D.C. Circuit, in about an hour, the Trump administration is seeking stays of both of Boasberg's orders, the temporary restraining order and the class certification. The period of time that is 60 seconds, but the CVS clinic is very small. Wait, what? But is it minute? So it's minute. It's a minute order. Okay. All right. Sorry. I thought I was being fancy, but I was also being wrong. Bye, Neil. Take care, darling. See you later, alligator. Let's see. So in today's proceeding, blah, 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 blah. There are at least 3 different kinds of jurisdictional issues presented. The threshold 1 is, are Judge Boasberg orders even appealable? Temporary restraining orders usually are not. The government claims, however, that these orders must be appealable because they create an immediate and, quote, unprecedented intrusion on executive power. That's right. Yep, Teresa, I believe that too. The plaintiffs maintain that there is no reason to depart from the normal rule that temporary restraining orders are not appealable, because nothing in Boasberg's order stops the government from arresting, detaining, or even removing alleged Tren de Aragua members under normal deportation procedures. Trump's second argument is that his Alien Enemies Act proclamation is unreviewable. What are you even looking at it? I don't even know why I need to put it up. And it is true that courts have found that some aspects of Alien Enemies Act orders to be unreviewable. At the same time, they've also recognized that other aspects of those orders are certainly are reviewable. Emphasis there. For instance, in the Luedecke versus Watkins, the U.S. Supreme Court reviewed the case of a German national who was arrested under the Alien Enemies Act in 1941 during World War II, a declared war. In that case, there was no dispute that he was a German national, that the United States was at war with Germany, and that the act applied to Luedecke at the time of his arrest. After proceedings before an alien enemy hearing board, to which there has been no remote parallel in the Tren de Aragua cases, the government tried to remove Luedecke in 1946. Luedecke then protested that the war was over. The president responded that while hostilities had ended, the war had not yet been formally concluded, a view that Congress shared. In 1948, the U.S. Supreme Court held 5-4 that in this posture, the president's finding about whether the war had ended was unreviewable. Ah, interesting. Quote, it is not for us to question a belief by the president that enemy aliens who were justifiably deemed fit subjects for internment during active hostilities do not lose their potency for mischief during the period of confusion and conflict, which is characteristic of a state war, even when the guns are silent, but the peace of peace has not come. These are matters of political judgment for which judges have neither technical competence nor official responsibility. I just don't see internment as really ever an option. Sorry. I'm sorry. At the same time, the majority also said courts could review whether someone was an alien enemy who came within the act. Quote, the additional question as to whether the person restrained is in fact an alien enemy 14 years of age or older may also be reviewed by the courts. See cases cited, note 8 supra. This question is not raised in this case. The footnote 8 referred to here listed more than a dozen precedents, including still binding D.C. Circuit rulings in which courts had engaged in judicial review to ensure that the statutory predicates of the Alien Enemy Act were met in particular cases. Last Friday, at a hearing before Boasberg, the Justice Department Attorney Ensign conceded that some statutory preconditions for invoking the Alien Enemies Act are, in fact, reviewable. But he insisted that such review could only take place in the context of a habeas corpus action. That gets us to the last issue, and maybe the most important, before the Court of Appeals today. The plaintiffs allege in their complaint that the government is acting beyond its statutory powers and violating the Administrative Procedure Act, the Immigration and Naturalization Act, and several other federal laws. They filed the case in the District of Columbia on the theory that most of the defendants, Attorney General Pam Bondi, Homeland Security Secretary Crispy Nome, and so on, live in the District of Columbia. But the complaint also lists the habeas corpus statute as a basis for jurisdiction. Habeas corpus is a remedy for plaintiffs in custody, but habeas ordinarily has to be brought where the plaintiff is confined. All named plaintiffs in the JGG case were in Texas on March 15th when the case was filed. None were in the District of Columbia. In fact, none had even been transferred to Texas from the district. So the government is pushing hard that assuming the Trump administration's actions can be reviewed at all, they must be reviewed in the Southern District of Texas. That's in the Fifth Circuit, whose Court of Appeals is widely seen as the most conservative in the country, even more so than the Supreme Court. Still, the plaintiffs have plausible argument that this case is not a habeas corpus case at its core. They're not seeking release, which is usually the focus of a habeas. They're not even challenging the conditions of their confinement. They're simply trying to avoid summary removal from the country without standard immigration law due process protections. Alas, today's argument may well revolve around the habeas question, the least interesting and most perfunctory of the extraordinary issues presented. The motions panel hearing the case is relatively conservative, as D.C. Circuit panels go. It will consist of Karen LaCraft Henderson, appointed to the district court by President Reagan and elevated to the D.C. Circuit by George H.W. Bush, Patricia Millett, Obama, and Justin Walker, Trump. So that's going to be something to watch today. That's right. Woof, woof. Whoop, whoop. Whoop, whoop. Hey, thanks for coming today. We did it. We did it. We really, really did it. So by the end of the day, I'll have all the links in the description. I want to thank you all for coming so much. Oh my gosh. We came back. Back again. Look who's back. Tell a friend. Please do tell a friend. Let's get this fucking thing to 1,000. This is ridiculous. Yes, Lee, we did. You had meetings. We solved problems. It's great. Well, actually, we probably just brought up a few more problems. What's with the Young and the Restless doing a Saw type scenario? What now? Oh, well, we'll be doing a space later on. Look for it under Gal Suburban because I'm banned from Twitter for a week. Yeah, banned on Twitter for a week. Yes, I am. Oh, I'm banned on Twitter for a week. I can't tell anybody to suck my fucking dick. And it's hurting my heart a lot. Oh, I'm banned on Twitter for a week. Oh, I am. Oh, I'm banned on Twitter for a week. Yes, go back to fighting tariffs. Jesus, Lee. It's like ticking time. Time clock. Ticking alarm clock. I'm banned on Twitter for a week. Yeah, now, Groove back with the lounge. Yeah, that's it. Man, hey man, take a look at the descriptions coming up for this week's Wake and Bakes because this bitch did some work for you this weekend. That's right. That's right. Yeah, next week's going to be a bitch. But yeah, you just take a look at the descriptions of the videos coming up and you make sure you hit that notification bell, God damn it. Okay? Boost my algo, motherfuckers. No, I'm kidding. I'm just kidding. Do whatever you want to do. I'm not telling you what to do. I don't want to tell you what to do. All right, my dog is going insane. He must have to pee real bad. Greenland condemns Usha Vance. Oh, that was my thing. I had this great joke about Usha. Well, it's not really a joke, but I'm like, okay, does Usha come in and like go visit the local pre-K, or does she come out strapped like Anna Paulina Lula with guns coming out of her tits and Greenlanders scurrying? Which Usha we getting? Just kidding. I don't know. I could see it happening though. I mean, I could see her doing that. I'm just saying. Hey man, I didn't marry him. She did, okay? Huh. Oh, I love you too. Thanks, you guys. Thanks for being here. Thanks for waiting for me too. I really appreciate it. I really do. You don't even know. All right. Okay, I'll see you later. I'll definitely see you tomorrow morning and probably talk to you tonight on Spaces. Okay. Have a great